That visual document. One case, madam, is pending, moving on issued, madam. Even the pending of the case, they issued an impugn order. So, my lord, I want to challenge that order by way of filing a IA. I've already filed. So, matter may be listed on, my lord, either fourth or fifth, because sixth is fit for holding AGM. Despite the specific order earlier passed by the court, they didn't consider our case, they didn't examine, straight away they issued the notification. Fourth.
Eviction matter, your lordship. I filed on yesterday, your lordship. It may be as production list, your lordship, want to be.
See, you will be writing it.
Yes, I have
early.
seen, your lordship. Because
There are many cases.
Because the fact is that 7 days time was given, and the 7 days time will expire on Sunday, your lordship.
Is the difficulty.
So that is the urgency, your lordship.
What kind of?
They are the shopkeepers, your lordship. They are doing their shops in the market, your lordship. And some other person, those who are similarly situated with the person, they have not been served the notice of eviction. But only these 5%.
Is the time permits, Mr. Khan?
As last motion item, your lordship.
It's the time permits.
All right.
Lordship, I beg your lordship permission for listing of 3 analogous items. Last listed in the month of December. So there are urgency, lordship. So kindly on 6th of March.
File mention memo.
Lordship, I will file.
On 6th of March.
6th of March.
No. After that.
Lordship.
11. May it please your lordship. Lordship, with the consent of the council for the GST lordship, I beg to mention item number 23, lordship.
Yes.
23, lordship. So, matter may be listed on first week of April, lordship. I have taken consent from the council for the GST, Mr. S.C. Kayal.
Mr. P.N. Sharma, Learned Counsel for the petitioner, has sought an adjournment in the case. What is the ground?
Lordship, the conducting council comes from the Calcutta, lordship, and
As the conducting council, it's not, it's has some difficulty to conduct the case. It is submitted that consent has been taken from Mr. S.C. Kyle, Learned Standing Council CGST, to make the prayer. First of, leave the. Yes,
may it be possible on 5th of April,
in the
lordship.
first week of April, on a date to be fixed by the office, the interim order prospective shall continue till the meeting.
Obliged, much of.
May I please ask you? I beg to mention.
Yes.
May it please your lordship. My lord, the Gurdwara committee, my lord, of Fancy Bazaar, before your lordship, my lord, some difficulties in-house under the 1860 Act, it will be a civil suit, not a writ petition. But we are not against anybody. We prayed before the registrar for our documents of election and all. He's not giving, the bank is also not cooperating. In such circumstances, strangers are trying to oust us. We have not gone to the police for peaceful things. May I pray at 2 o'clock, my lord?
No, see, Mr. Banik, it is very difficult. Already 35 motions.
I squarely understand. Otherwise, for the langars to be done, the salaries to be paid, everything to be done, my lord.
Monday.
Saturday, Sunday also coming in, my lord. May I take a chance if lordship permits? Only a direction to the registrar to give the documents, my lord. Much difficulties to manage people, my lord. Otherwise, I would not make a mention, my lord. If lordship considers, my lord.
Okay,
Christ, my lord.
no more. No more
Yes,
motion
yes.
mentioned.
Yes,
Mr.
I beg to
Khan,
mention.
are you mentioning?
I beg to mention listing for the listing, my lord. And next week, my lord, any date.
Not next week. Yeah.
Obvious.
May it please your lordship. Item number 24, my lord. My lord, the respondents are yet to file the affidavit. We had been informed they will be filing within 3 weeks. My lord, matter may come up after 3 weeks of any date.
Okay, on prayer of Mr. H. Petala, Learned Counsel for the petitioners, raise the case after 3 weeks when it is to be fixed by the office. The respondents shall file their counter affidavits in the meantime.
Lord, may I pray for a fix it by wait, file your blessing.
May it please your lordship, item number 32 of the main list. Your lordship, I have been instructed to not press this matter, your lord.
32.
Yes, your lordship.
MS
S. Newar.
S. Newar, Learned Counsel for the petitioner, has submitted that she has received instruction from the petitioner not to place the contempt petition. In view of the above submission made by MS Newar and counsel for the application, and the contempt petition is closed.
Obliged, your lordship.
Your Lordship, WPC number 8426/2022. Your Lordship, matter may be listed on 5th of March.
What is your subject matter?
And the matter is on about the eviction of land by the railways.
Whole matter?
Yeah, it's
Make a pursue before the race.
For withdrawal, item number 33.
May please your lordship, my lord, in view of the dissolution of the marriage between the parties, my lord, which has been, the decree has been passed by the family court at Kerala, my lord. This petition has become infructuous, my lord.
Mr. D.B. Boral and counsel for the petitioner has submitted that in view of developments which occurred in the interim, the subject matter of the petition has become infructuous.
Your lordship, if your lordship indicates that due to dissolution of the marriage between the parties.
Developments
Yes, my lord.
in the interim,
Yes, ma'am.
the subject matter of the petition has become infructuous. We have the above submission made by Mr. Boral and for the petitioner, the petition is dismissed as infructuous.
Obliged, my lord.
So motion item number 1.
Lordship, I am appearing for the GST department. I was supposed to file additional affidavit. Lordship, that is ready, but we could not file due to some technical reason. Maybe taken up next week, Lordship. The matter is relating to gratuity, payment of gratuity.
Okay, we can issue notice then.
Lordship,
We can issue notice only single respondent.
yes, Lordship.
Otherwise, there is an appeal.
No, Lordship, here we are challenging because our preliminary objection was not considered. Our preliminary objection was not contained. The authority has decided the case on merit, Lordship.
Preliminary objection that you are,
Yes, we are.
but your whole argument is based on Industrial Disputes Act.
Lordship, that is correct. But Lordship, what happened in this case? We filed an objection, but that was not decided. And in the meantime, the petitioner, along with they approached the learned CAT for seeking permanent status of their service. So both portions are contradictory.
Because your whole argument is based on industrial
Yes, Lordship.
in all disputes act.
But our condition is that we are not fall under the definition of establishment because we are discharging sovereign function. And admittedly, the respondent number 2, he was Lordship temporary employee.
Law is settled otherwise.
No, Lordship, I have gone through after Lordship discussion. I've gone through, but this is the only point Lordship I consider it. And
Or
this-
Mr. S.C. Kar, learned counsel for the petitioner. The present petition is preferred. Assailing legality and validity of an order dated 26/7/2023 passed by the controlling authority under the Payments of Gratuity Act, 1972. Full stop. Whereby the controlling authority has held that the respondent
number 2.
number
2, Lordship.
2 is entitled to gratuity under the provisions of the Payments of Gratuity Act 1972 and has quantified the amount of gratuity at rupees 4,01,262. Post of issue notice to the respondents. The notice is made returnable on 3rd April. Who will appear CGC?
Lordship, they're engaging counsel, Lordship.
Okay, the petitioner shall take steps for service of notice upon the respondents by registered post with AD within 2 working days of payment of gratuity. The petition is preferred despite availability of the remedy of appeal
Under section 18.
under section 7
Lordship, probably 8.
7 within bracket 7. Of the payment of Gratuity Act 1972. So as such, the question of maintainability stroke entertainability of the writ petition is kept left open for consideration, on the return.
Lordship.
Item number 2.
Lordship, in this case, their contention is that they never received neither notice nor impugn order, Lordship. Lordship, I was supposed to obtain instruction. Lordship, issue notice in the meantime.
Yes, Mr. Mishra,
My lord.
why a notice, if it is uploaded in the portal,
No, it
is not sufficient notice?
It is a Finance Act, my lord.
Huh?
It is, the order was passed under Finance Act, my lord.
Finance Act.
Finance Act.
Hmm.
And my requirement is that they have to send it by speed post, section 37C of the Central Excise Act 1944, my lord. It is
Let
also
us
the
see. Heard Mr. R.S. Mishra. Learned counsel for the petitioner. And Mr. S.C. Kayat. Learned standing counsel CGST.
Lordship.
For the respondent number 1 to 4.
My understanding is appearing for 1.
2 to 4. Full stop. Also had MS.
Lordship, P for Gary on behalf of CGC Mr. SK Medhi. On behalf of SK Medhi.
You know? For the respondent number 1. Full stop. By which provision it is made applicable?
My lord, section 83 of the Finance Act, my lord. 19.
Finance Act আছে? Service section. Section
My lord, 83 of the Finance Act.
83.
3, my lord, of the Finance Act 19 94, whereby my lord, section 37C of Central Excise Act was made applicable in the Finance Act, my lord.
The requisition is prepared by the petitioner on the contention that the copy of the show cause notice
My lord,
dated 7/7/2020, on the basis of which the order in original dated 19/7/2021
my lord,
was passed, was never served upon the petitioner in compliance of the provisions of section 37, capital C of the Central Excise Act 1944, which provision is made applicable to the Finance Act, which provision is made applicable to the Finance Act 1944
1990.
by virtue of the provisions in section 83 thereof. This provision is made applicable to the Central Excise Act 1944. No. This is a finance case, Finance Act.
Finance Act 1994.
Hmm?
Lordship, service tax.
Service tax.
Okay. On the basis of which the order in original dated 19/7/2021 was passed. Where is the show cause notice?
It was never served, my lord.
Okay, it was never served.
My lord, annexure B, my lord, page 16,
It
recovery.
was purportedly under section 73.
My lord, 73. For the
Okay,
Finance Act.
okay. And I can look at that. So the copy of the show cause notice dated 7/7/2020, issued purportedly under the provisions of section 73 of the Finance Act 1994, pursuant to which the order in original dated 19/7/2021 was passed, was never served upon the petitioner. Full stop. It is the contention of the petitioner. The show cause notice, such show cause notice is required to be served upon a SSC notice by following the provisions of section 37C of the Central Excise Act, 1944, as a said provision is made applicable to the Finance Act 1994 by virtue of section 83
My lord.
of the Finance Act 1994. Full stop. Mr. Kyle is standing as a CGST who had sought time on the previous two occasions, has submitted that he is yet to receive the instructions. Issue notice returnable on 3rd April as MS so-and-so, and Mr. Kyle has appeared and accepted notice on behalf of the so-and-so, respectively. Issuance of formal notice is dispensed with. Extra copies within 2 working days. Yes.
Lordship.
What is it?
In the meantime, no courtship.
In view of such assertion that the show cause notice was never served upon the petitioner, comma. It is observed that till the returnable date, comma, the responding authorities shall not take any coercive action on the basis of the impugned order in original dated
19/7/21, my lord.
19/7/2021.
Much.
Deeply aware.
Item number 3.
Lordship, please.
So in this matter, we have been asked to take instruction as regard the proceedings which has taken place prior to one. So I have my instructions.
Mr. Fugan, you said 3 proceedings.
Yes,
2 are pending or 3 are pending?
3 are pending.
3 are.
Yes.
The third paragraph would
None.
specify, yes.
It appears that Sulema Khatun,
She's the
she
complete.
made a complaint
Yes,
before the circle officer.
yes.
Then, failing to secure the presence of the petitioner, circle officer forwarded the matter with a report to the district commissioner Soraideo. Then, after receipt of the report by the district commissioner directed the subdivisional officer Soraideo to conduct an inquiry. And during that time, another complaint was filed by Sulema Khatun before the Superintendent of Police, Vigilance and Anti-Corruption. And the Superintendent of Police forwarded the matter to the District Commissioner. So District Commissioner forwarded the petition of Sulema Khatun and the SP's letter to the additional District Commissioner Revenue to get the matter inquired. So there are 2. Any other?
The first proceedings is before the circle officer, that is 24/5/2003. 23. So that's the first proceedings before the circle officer.
That was forwarded to the Deputy Commissioner with a report,
Yes,
and Deputy Commissioner in turn forwarded the matter to the Subdivisional Officer Hodor
right.
to get the matter inquired. Then at the same time, Sulema Khatun submitted one complaint before the SP.
Yes,
SP again forwarded
yes.
the matter to the district commissioner. District commissioner this time had forwarded the matter to the additional deputy commissioner to get the matter inquired. So basically the complainant is one,
Yes,
the mutation proceeding is one, and the opposite party is one, that is you.
yes.
And it appears that you are a government servant, not a private person. That is what the deputy commissioner says. You are a
I
Gaon Pata.
was a Gaon, I believe. I
He
was
is
still a
a
Gaon.
Gaon-
Oh, he's
being
still
a
a Gaon.
Gaon.
He's still
He's
a
a government servant.
Yes, he is still a Gaon.
So any allegation against him should be inquired internally before any departmental proceeding. So it is a fact-finding inquiry. There should be participation from your side also.
In fact, on the first proceedings, Your Lordships, we did wanted to participate, but we were not allowed to participate, for which, but
So this court directed.
yes, in terms of that, now after Your Lordship's directions, I think we participated in that proceedings. Circle office. Now subsequently, we have pointed out about the two proceedings, one which Your Lordships have now said
Yes,
it has been now
circle
transferred to Sadar,
Transferred to
Yes.
SDO
SDO on
Sodor.
second, Sadar.
Sodor.
And there is another complaint which is before by the superintendent,
That
Again
is
has been forwarded
now
to the-
Before additional deputy commission.
again forwarded in regards to the same subject.
Almost save something.
So if everything can be compiled as one, Your Lordship, then at least,
And
Ah.
since you are a government official also,
yes,
I think you should participate
I
in the
will,
fact
I will,
finding
I will
inquiry.
participate. I will. Oh,
Whatever is there,
Yes.
along with you, some more Latmondol and Latmondol. Well, Latmondol was also brought to the,
I
has
see.
been brought to the net.
Okay. I am ready to participate. There's no problem. Only thing is because there were two multiple proceedings and initially I was not allowed. If
Right.
Your Lordships can at
One
least,
should not face also multiple proceedings.
that's all, that's all my.
Before
grievance is.
different authorities.
That's all my
Mr.
grievance. If one proceeding,
Borua.
I'm ready to participate.
What do you say? Basically, the complaint is Sulema Khan.
Sulema Khan
And authority, both the authorities, that is subdivisional officer
in the circle.
and additional deputy commissioner, both are under the district commissioner. So district commissioner get the matters clubbed and so that the proceedings can be conducted before one authority.
One authority.
Because
grateful.
complaint is one, allegations are same.
Allegation same.
The opposite party facing the fact-finding
also
inquiry,
one.
like the petitioner, is the one.
Let the petitioner.
Why two proceedings?
Let the petitioner cooperate, in fact.
Cooperate? What do you say about that?
Um,
Can you get the instruction from the deputy commissioner?
No, in fact, it is very clear as regard the fact finding. This is an internal inquiry which has to be done before the departmental.
Okay,
proceeding.
then we can,
Yes, lots of may observe that and close it.
And yes, only one indulgence from Your Lordships. On the previous occasions, the lawyers were not allowed to go and participate. If
this
Your
is
Lordship-
fact-finding inquiry, Mr. Fukon,
If at all,
not
if
a
at all there was
departmental
if
proceeding.
at all, I just leave it to Your Lordship. That's all I'm
Deputy
saying.
commissioner said that it should have to be inquired internally before
I agree.
departmental proceeding is instituted against him.
Yes,
Yes.
no problem.
So this is, there is some allegation of misconduct as a public servant.
Yes.
So they want to inquire.
Initial inquiry has to be.
So it is not a, for imputation.
What I have been instructed to inform is that the complaint has apparently been filed as a private respondent, not as a Gaobura. So that part I'm not.
But now this
Yes, in terms of the
supervision
support, it
cannot
looks
go
like,
and
yes.
all this have been
Yes,
involved.
I leave it to Your Lordships.
Art, Mr. R.B. Fukon. Learned counsel for the petitioner. Yes, you have any role?
At the moment,
Huh?
yeah, formal party.
Mr. A. Fukon,
Respond number one.
learned standing counsel, Guwahati General Administration Department, GAT. For the respond number one, MSG Hajuri. Learned standing counsel, Revenue and Disaster Management Department for the respondent number two. And Mr. S. Borua, learned counsel for the
346.
respond number, Junior Government Advocate Assam for the respond number 3, 4, and 6. Having regard to the issues raised
No, this, you cannot proceed with the number of
In-
proceedings.
this writ petition. And in view of instructions received in deference to the previous orders of this court, this court is of the, this writ petition is taken up for consideration as there appears no necessity to issue formal notice to the respondent number 5 and the party respondent number 5 and the party respondent number 7 included in this writ petition. The basic grievance of the petitioner is that one Sulema one Simari Sulema Khatun made a complaint alleging made a complaint made complaints before different authorities in the establishment of the Deputy Commissioner, District Commission, Soraidu, alleging that in respect of a plot of land in respect of two plots of land, covered by DAG number 29 and periodic patta number 1 and DAG number 426 and periodic patta number 160, situate at which village? No Kosari, Gao, Revenue Village.
No,
Correct?
Yes.
Moja, Abhoypur. Sonari, Revenue Circle. Soraidu.
Sorry.
District Soraidu. There was illegal mutation, stroke partition. Also. One complaint, one complaint. A complaint, a complaint. The same complainant, that is Srimati Sulema Khatun, implemented herein as party respondent number 7, also made a complaint before the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam, and the said complaint was forwarded to the office of the District Commissioner, Soraidu, by the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam, by a letter dated 14/12/2023. In respect of the first complaint, mentioned herein above, the circle officer, Punari Revenue Circle, had initiated an inquiry by issuing notice to the petitioner and Srimati Sulema Khatun for the purpose of ensuring their appearance before him to conduct an inquiry. Poster. As regards the allegation made in respect of mutation stroke partition relating to the plots of land, aforementioned 2 plots of land. Poster. Due to various reasons, the circle officer, Punari Revenue Circle, forwarded the matter with a report to the District Commissioner Soraidev. Poster. On receipt of the report from the circle officer, Punari Revenue Circle, the District Commissioner had directed the subdivisional officer within bracket S, Soraidev, directed on 26/12/2023 to conduct an inquiry into the matter. Poster. Similarly, after receipt of the letter from the Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam, the District Commissioner Soraidev forwarded the petition of Srimati Sulema Khatun to the Additional Deputy Commissioner Revenue Soraidev to get the matter inquired. From the instructions placed by Mr. Burwal and Junior Government Advocate Assam, from the instruction communicated to Mr. Burwal. Right. Letter number so dated 28 February 2024 of the Deputy Commissioner, District Commissioner Soraidev, it is noticed. Mr. Phukpan, learned counsel for the petitioner, has submitted that in view of 2 proceedings pending before 2 different authorities, on the same subject matter. uh, Started on the basis of the same complainant, that is the party Srimati Sulema Khatun, comma, the petitioner has a genuine apprehension that different proceedings before different authorities will have the possibility of passing conflicting orders on the same subject matter. Full stop. He has pointed out that, oh no, that's gone. That earlier proceeding is gone.
Yes, that's all one.
Full stop. Mr. Borua, learned Junior Government Advocate Assam has submitted that, has fairly submitted that the proceedings before the proceedings pending before the subdivisional officer as Soraidew and the additional district commissioner revenue Soraidew are more or less on the same subject matter. Full stop. He has submitted that for the purpose of consistency, it is expedient that both the proceedings may be conducted by the same authority. From the instructions placed by instructions of the Deputy Commissioner, from the communication dated 28 to 2024 of the District Commissioner Soraidew, in the communication, the Deputy District Commissioner Soraidew has conveyed that since the petitioner, being a Gaon Pradhan, is a government public servant, there is necessity to inquire any allegation against him internally before initiation of any disciplinary process, departmental process. Full stop. From the same from the it appears from the same instruction that the proceedings initiated the two proceedings pending initiated against the petitioner and others are in respect of the allegation made by Srimati Sulema Khatun regarding illegal mutation stroke partition of the aforementioned two plots of land in the nature of fact-finding inquiries. Full stop. In such view of the matter, this court is of the considered view that it appears more expedient that for the purpose of consistency and for avoiding conflicting orders in respect of the same subject matter, the district commissioner shall get the matter inquired by the same authority that is either by himself or any authority under his supervision, as the case may be, as found expedient. Full stop. That will do. The petitioner shall ensure his participation in the said proceeding for the purpose of facilitating the petitioner's appearance, the deputy commissioner or the authority who will be entrusted to conduct the inquiries, shall serve due notice to the petitioner prior to due notice to the petitioner. It is observed that no, it is not required. Full stop. It is observed that the deputy commissioner shall fix the date of such hearing on, say, January, March.
Any date convenient to your lordships, no.
Huh?
Any date convenient.
2003.
Date, I cannot sure about the date because.
Otherwise, everything will get delayed. Okay.
No,
Okay, then.
that is for the
Okay.
discussion. Could be left to the discussion.
After taking a decision, after taking a decision, after taking a decision for consolidation of the proceedings, the deputy district commissioner shall serve the petitioner should be duly intimated about the date of hearing for his participation in the proceedings. With the apposite observation, with the observation made and direction given above, the petition is disposed of.
Great.
Item number 4.
May I please, your lordship?
Yes, anything?
Yes, we have it. And in fact, from what we have got from the instruction, it appears that based on the FIR, the inquiry has been conducted, but the petitioner has been called, accused has been called, but he was absent in the inquiry.
Inquiry, I have the honor to state that
Yes.
complaint on this housing affairs.
The last two paragraphs.
Under what provision of law he is asking, calling for his appearance?
Yes.
Under what provision of law he is asking for his appearance?
Because FIR has been lodged, that is the
FIR
allegation.
is not registered. FIR is not, it seems FIR is not registered. If I have read it correctly.
I have the bunch of documents and attached there.
Go through it. Whether FIR is registered. FIR is not registered. He has made a GD entry.
GDNK.
GD entry. Now, whether it is not, it appears it is a check bouncing case. If you read it,
Yes.
check bouncing case, then on the basis of that, the lady has lost an FIR which has not been registered, made a GD entry and asking for the petitioner's appearance.
But
Meaning thereby it is not a cognizable offense.
the complainants,
It is a parallel proceeding. Once the complainant, lady has instituted an 138 proceeding before the 3GM.
Yeah, before CGM.
Now, along with that, another FIR on the same subject matter.
I understand.
Just to extract whatever he may have committed something, that is a different matter. That will be taken care of by the court in the proceeding. Now that lady has filed another FIR on the same subject matter, and police is calling the petitioner without registering any FIR. Had it been a case registered and calling him, that is one matter. Whether police is empowered to call any person, citizen, just for the sake of it, when it appears to be a case of harassment by the lady.
If at all,
No, CRBC particular.
the petitioner is trying to portray a case of harassment, but this is only with regard to the inquiry based on the GD entry, whether law-abiding citizens should cooperate with the proceeding or not.
Then you ask him by serving notice under 41A.
Yes.
If it is you are so interested to make
Extract the truth,
enquiries,
extract the truth before any FIR has been registered. So that's what I can
if
make out from.
is that police officer in all cases where the arrest of a person is not required under the provisions of so and so, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the.
Yes. No notice could have been.
Heard Mr.
I.S.
Mojumdar, learned counsel for the petition, and Mr. S. Borua, learned junior government advocate Assam for the respondent number 1 to 4. Full stop. Mr. Mojumdar, learned counsel for the petitioner, has submitted that the respondent number 5 has instituted a complaint case under section 138, negotiable instruments at 1881 as amended. In respect of alleged dishonor of a check amounting to rupees 1 lakh issued by the petitioner. Full stop. The said complaint case has already been registered as complaint case number 4177 2023 before the Court of Learned Chief Judicial Magistrate, Kamrup Metro, Guwahati. Full stop. Mr. Mojumdar has had full stop. The writ petition is instituted with the grievance that with the contention that on the pretext of the said complaint case, the respondent number 4 has been asking the petitioner to appear before him comma, without any case being registered against the petitioner.
Yes, ma'am.
Full stop. It is a contention of the petitioner that the petitioner could not have been called to the police station without following due process of law. Full stop. When the writ petition was moved, listed on 19 to 2024, comma, Mr. The learned State Council. The learned State Council was asked to obtain instructions as to whether as regards the allegation, as regards the grievance raised by the petitioner, full stop, Mr. Borua, learned State Council has placed a report from the respondent number 4, comma, addressed to him. Full stop. From the report, from the same report, it appears that the petitioner and the complainant in CR, complaint case number 4177, 2023. No, petitioner, the complainant in complaint case number so and so had also lodged a first information report at the dispute police station on 4/11/2023. Full stop. The petitioner and the complainant are relatives, and full stop. From the report, comma, it transpires that a dispute is going on as regards a matter relating to release of the complainant's husband on bail. Full stop. Reference has been made in the report also to the matter of dishonor of a check amounting to rupees 1 lakh issued by the petitioner in favor of the complainant and about pendency of the complaint case number 2477 2023.
4177 or 4177.
41 or 24? Are you sure?
Complaint case, NI 41.
Okay. Complaint case number 4177 2023 before the Court of Learned Chief Judicial Magistrate, Kamrup Metro, Guwahati. Post op. On the basis of the said FIR lodged by the complainant, that is complainant, comma, a general diary entry was made by the respondent number 4 has stated that a general diary entry was made and one sub-inspector of police attached to Dispur police station has been entrusted to inquire into the matter. Post of after examination of the complainant in the course of inquiry, the said sub-inspector had asked the petitioner to appear before him at the Dispur police station for the purpose of recording his for the purpose of recording the statement of the petition. Full stop. As a petitioner, full stop, the report of the respondent number 4 has further mentioned that the petitioner did not turn up before the sub-inspector of police who has been entrusted to inquire into the matter on the basis of the FIR lodged by the complainant. The report has further suggested that Para. In view of such, in view of the above report, submitted by the respondent of court, it is observed that for the purpose of notice, for the purpose of securing appearance of the petitioner, there shall be due observance of the provisions contained in the Code of Criminal Procedure 1973, more particularly, the provisions contained in section 41A of the thereof. With the above observation, the petition is disposed of. A copy of the report. Yes, the copy of the report. Kept.
In fact, one line may be added if at all his presence is required by observing the provisions.
This is what?
Yeah.
Observing the provisions.
Sure.
Have you not heard?
No, in fact, I have misheard it as regard whether that his presence is required only under the provisions, but since that hasn't been done, so it's.
It is observed that for the purpose of securing the
Presence.
appearance of the petitioner, due observance
Yes.
of the provisions of, there shall be due observance of the provisions of CRPC, more particularly section 41A thereof.
All right.
Lordship, on last occasion, we were asked to take instruction.
Yes,
Lordship.
shifting.
And the petitioner is already a beneficiary holder of a pipe water supply scheme, Your Lordship. That's why the area was shifted.
What? Are they going to install the pipe on the same villages or not? The scheme has been sanctioned for three villages, my lord.
1 minute. Let us see. Your inhabitants of village Tongia Gaon.
Yes, my lord. The scheme has been
Drinking
sanctioned.
water scheme was sanctioned for Ambari Gaon Panchayat.
No, my lord. Scheme was sanctioned for Gosaigao, Tongia, Lonkazan, three villages.
Under Ambari Gaon Panchayat.
Ambari Gaon Panchayat, my lord.
Three
For
villages.
Three villages. Gosaigao,
Tongia and
Lonkazan, my
Lonkazan.
lord.
Okay.
And
Lonkazan, Gukhaigaon,
and
Tongia.
Tongia villages. For
So you are from Tongia.
we are from Tongia, my lord. But they are not going to.
You are not interested in Gukhaigaon and Lonkazan.
No, my lord.
You are Tongia, remain on Tongia.
Tongia, but we are
Don't be
we are interested to install the scheme under as per pinpoint, my lord. Maybe at
You are
Gosaigao.
from Tongia.
Yes.
And Jal Jeevan Mission was sanctioned for Gukhaigaon, Tongia and Lonkazan.
Lonkazan, yes, my lord.
Now, your allegation is that the department is contemplating to shift
It to
the-
another village, that is my lord,
Section.
Ambari Forest Reserve village.
to another village within Ambari Gaon Panchayat.
Another village that is named Ambari Forest Reserve village within Ambari Gaon Panchayat. Another village, not in three villages.
Okay.
So we are paying to install the, my lord, to implement the scheme. as
When,
per
when,
PIN code.
where the Jal Jeevan Mission was supposed to be installed earlier? See,
Well,
I'm asking you,
yes,
that mission was, that scheme was, or whatever plant,
Yes.
plant,
yes, my lord.
water supply plant,
My lord.
was meant for Gukhaigaon, Tongia and Lonka.
And village people.
So it will be installed in either of the three villages
Yes, my lord.
where it was supposed to be installed.
Any my lord, they are to be inquiry.
Now, where from you are saying?
It was supposed to be
Well, we are the village-
Narasimha
we are the villagers
Patti,
of
Tongia,
Tongia, my
and,
lord.
it was supposed to be installed Narasimha Patti, Tongia Forest Village, Your Lordship.
Tongia. Statement may, but photographs project actual pictures. Statement may differ.
Photographs.
Photographs speak the truth. Narendra Namohudra, Prabhat Namohudra, and Madan Namohudra.
All the three petitioners, Your Lordship.
All the three petitioners are enjoying the benefits of already installed water supply scheme.
Regarding, I have no instruction.
Their houses photograph, their installed pipeline in their residence with your petitioner's photograph along with that.
I am to take instruction.
That belies your statement. Already installed a scheme. Somehow, because of their miscalculation, again one was
About to be installed. It was
was
rectified later.
supposed to be installed.
But it was
And
rectified.
realizing their mistake, they have shifted the thing because already a water supply scheme is installed.
This scheme.
And your
Scheme.
This name is Konaklata.
Whether this scheme is the present scheme or
no,
He has already a scheme, Your Lordship.
already Kamalakanta Basti PWSS water is being supplied to the stakeholders as per the discussion with the water users committee of the said PWSS.
Then, my lord, I am.
It cannot be that I want to have more.
It is not a case of the petitioner that they wanted to install it on their land, my lord. They
No,
want it.
Otherwise, normally.
It should be installed, my lord, as per
Normally,
pinpoint, my lord.
photograph,
Within 3 villages, if it is installed, we have nothing to say, my lord.
no. Normally,
Maybe old scheme, maybe here, which is not suitable for the petitioner. But it is a present scheme or not, I have no information.
already these water taps are there.
Maybe, my lord, old
Your
scheme, maybe.
instruction.
But,
Take your instruction.
yes, we have to take instruction. Let them file a VDPT also if.
Why should we keep it
Yes.
pending if your water tap is installed in your houses?
My lord.
Then we'll think of
Yes.
imposing cost,
Yes. Well,
right?
whether it's a present scheme
So
or
that,
not, whether it is present
It's
scheme
not
or
about
not.
the
it is-
present scheme or past scheme.
whatever. If you have your water taps
My lord, my
installed
lord.
in your houses and you are getting water already,
Hmm.
what grievance you have? This is not a public interest litigation. If these three petitioners
My lord,
are already having water taps installed and enjoying water
my lord.
from already installed Jal Jeevan Mission scheme, then why they are aggrieved? They are no legal right violated.
They are only saying, my lord, they should.
Don't espouse the
Yes,
cause
my
and go for a PIL.
Sorry, my lord.
We only
Sorry.
see Narendra Namarasutra, Prabhat and Madan.
My lord, I am taking.
And we have the photographs with us.
Yes, my lord, we take it.
So if you want public interest
yes, yes.
litigation, file
Yes.
public
Yes.
interest litigation.
Sorry, my lord.
Your legal rights are not being violated.
Yes, my lord, sorry.
And these are all of 20th February 2024.
Yes, recently. Yes, sir. Yes, sir. I'll take instruction on that.
You take instruction.
Sorry.
If it is installed,
Yes.
heard Mr. B. Roman, learned counsel for the petitioner. R. Gogoi, learned standing counsel public health engineering department for the response number 145. And S. Borua, learned junior government advocate Assam for the response number 2 and 3. So stop from the instructions placed by Mr. Gogoi, learned standing counsel PHE department from the executive engineer PHE, Hujai division, Hujai, it transfers that and the photographs enclosed therewith, it transfers that all the three petitioners are having water connections from an already existing, what is PWSS?
Pipe water supply scheme, your lordship.
Pipe water supply scheme named Kamalakanto Bosti PWSS. Full stop. If the said statement, such projection is correct, the petitioner, the three petitioners may not have any legal rights to institute the present petition. Mr. Roman, learned counsel for the petitioner, has sought for listing of the repetition after a week in order to obtain instructions from the petitioners. Please the case answer.
Item number 6.
Please, your lordship.
Yes,
Well, I
anything?
took the instruction. They are my learned friends are right. So far as the diagnostic center, they were just digging it from very beginning. But once they came to know, then they stopped. So far, they knew that public at large will suffer. So far, a diagnosis center. So that part has been taken care of as on date. If we don't know, I cannot anticipate and say that please.
No,
contact
it
us.
is so.
Whenever it arises, then they, of course. But so far
Because
as
the deputy commissioner is making a statement.
yes, but so far as the other part is concerned, that part, what is there, I have seen photographs also. That part is a difficulty is there because there is no entry and exit. Some wooden plank they have put in, I have asked them, but they have surrounded by some bamboo structure so that there cannot be entry and exit through those commercial places. Only my prayer, limited prayer before your lordship is that if they start, because they said that drainage problem is there, so definitely we have to cooperate. And I have seen, my lord, my house also, any house, there is a culvert which it goes, the car goes inside. But ultimately, that is the government, which part. One has to make entry and exit. Only my limited prayer is that if they allow, there's to only for entry and exit. For those commercial players, it will solve. And whenever there is a problem, so drainage will cooperate with them, my lord. And so far, I cannot say that this is my land or their land. It is the area of a civil court which will decide. Only that part I am asked, just praying before this court if there can be an entry and exit point.
Because it is also difficult to visualize everything at
Yes,
the,
yes,
at the ground.
Yes.
Mr. Borua, any further instruction?
No.
No, what I took my.
Make a representation then.
We'll make a
Make
representation.
that commercial establishments, other than the diagnostic center, if they are facing difficulties, make a representation before the deputy commissioner so that a working solution can be granted. Then we can observe that if you require, then if and a region order should be passed. We can do that because so far the owners are not here.
Yes, I am the.
I
know, that's right. That's
the
right.
other thing is.
That's right.
Other thing is, it is some disputed thing, all this exercise will be
No,
required.
no, I am not troubling this court regarding about the area, whether it falls my
Yes,
area,
yes.
whether their
That will
area.
be
That's
a
a
huge
civil. Only the question is only the entry and exit point. That's the only point, and is a fact. It is a fact on record that they have broken the entire path. A lordship has seen that. Now I have to jump over to get it. That is only, it's not possible.
Now, so far petitioners
can-
diagnosis center is concerned.
That is safe.
That
is
is
safe.
That
So far,
there is
yes,
kept-
that they have kept it as on date now. What we can do it, my lord, we'll represent the matter. We'll represent the matter.
because those are not here.
But we'll.
Those whose
No, that's
business
correct. That's correct. That's
is
correct.
affected
And that-
because
Your lordship will
directly
observe.
they are not here.
Your lordship will
You are
observe.
not running that IMFL shop.
No, that's right. But it is under my.
You are a
being
doctor, right?
So I have to protect.
You have to protect
the
it.
tenant. That's only. My
In
lord.
a REIT jurisdiction, it is difficult to go beyond this. Yes, you are running something which is addressing the public.
Only some.
The other is not
My lord,
addressing the public cause.
Only to give a
The
flag.
shop I have seen,
Only to give
that
a.
is not very, that is less extra commercial.
No, that's my lord. Even
They may hesitate.
no, that will do it. My lord, it's only the ventilating the grievance because we being a landlord, the landlord has got certain rights over the tenant. Had to be protected. Only for
Those
that
are the landlord, tenant, this is too far because.
No, that's I'm not saying that your lordship will decide landlord tenant dispute. Is only ventilating the grievance of the tenant to a REIT court only for the purpose of entry and exit. That's all. The government has come and broken that particular saying. And what I have gathered, well, I don't want.
Because since you are running a diagnosis center.
That's true.
Which is serving a public cause. Even as a, what I can say, not a private venture. Still it is
Not right. That's correct.
addressing the patients. We
right.
were alive to that situation.
That's correct.
We are not alive, very alive to that other establishment.
Only the problem.
This is going bit ahead of.
No, only why it's entering into the area of 226 only to the extent because if it was a purely a private dispute, then it is not an area where lordship will decide. It is a government who has taken action in breaking that particular where we cannot entry into it. So ultimately, my grievance will lie under 226 only if the government is taking an action against that. What we can do it, my lord,
They are the fallout. The government is taking action against you.
Correct. Right. Correct.
In the process, they are the
they are the
they are the sufferers.
Yes, right. That's
Right,
only,
it is not directly,
My
not
lord, that-
directly,
I
because
cannot,
in the process they have suffered.
lordship cannot expand to that particular
That
area.
is the
Only to
difficulty.
the extent that seeing the difficulties. Now, on the face of it,
Ask Mr. Difficulty is Mr. Das, that, okay, you being the landowner, that your building has been demolished,
my building
or whatever
Good.
part of front
Yeah.
part is demolished, whatever,
Yes.
demolished, and you are running a diagnostic center there. So we can relate. But relating them through you to the public, this commercial establishment, shops, that is bit going too far.
But again, if I come, the tenant comes here, ventilating their grievance also.
Let them represent, because otherwise their rights are through you only.
That's the whole difficulty.
And their rights are through you.
To protect my tenant also, my lord. The only grievance that suppose tomorrow, my lord, are we coming to High Court and that particular culvert is broken, how will come, my lord? It's the government has to make some arrangement. I am not saying we are cooperating, we'll cooperate. I am not saying we will not cooperate with the government.
No.
Some entry and exit so that we can go
So
inside.
that who has committed the wrong earlier? You or the government?
No, that way I can't comment. Your lordship neither cannot decide. Only
We cannot decide.
Not decide by your lordship cannot decide, but only to the extent that I got an occupancy certificate, that your lordship will kindly see in what manner. Initially, there was a complaint, and that complaint said that certain violation of that building, some violation was there. They examined, and ultimately they did not find anything. Subsequently, they put some red mark, they put it. My lord, will kindly is a sequence, and the purpose for which they want is for broadening of the road. Absolutely no problem. They can take my land also. But what report says it is for the purpose of drainage. No,
And
there is something.
to determine other issues, we need their response also.
No,
detailed
that's true, my
response.
lord. That's true. I will not trouble.
We will not go to the other commercial
So that
establishments.
my lord, that also.
We are only concerned because diagnostic center,
No,
you are
that's
running
true. My lord, two
not as a
prayers.
charitable institution, but still he was
Two aspects. My lord,
providing
your lordship.
treatments, providing something to the public, ailing public. On that basis,
Two
we say.
aspects.
But we will not go beyond that.
Then of course, I will.
At this
why
stage,
I
we
will-
are not going.
Why
At
I
this
will-
stage, we are not going. Because we see what kind of public.
My lord, my argument also, I know the psychology of the court also. I will also not say something to waste your lordship times. So your lordship is determined that I will not go into that aspect of the matter.
As on that, we are not.
That's why I know, my lord. I know it, my lord. Practicing here also, I know it. To what extent your lordship can enter into that area.
Because they are not making any grievance.
No, only the grievance which
Just because as a landlord you are trying to protect their interest, we will not go into that
No,
aspect.
then of course, my lord, if
That
your
is going too
lordship,
far.
no, that your lordship doesn't want to go it, then tenant has to come into it, their
Maybe
individual
that is
right.
a
I
different
don't
issue.
know, my lord.
Maybe a different issue.
Yes.
But at this stage, we are only, since the
we'll do it.
deputy commissioner is saying that there obstruction in, there is no obstruction in the entry and exit. So we can say that the parties shall maintain status quo as regards entry and exit
Yes.
to the diagnosis
No,
center.
and plus your lordship will just add one thing. They will represent the matter also before the government. So
No,
for
we
the
are
other aspect,
issuing notice.
yes,
We are issuing notice.
yes, pending, you're right, correct. Pending will not be barred to represent the grievance of the landlord or as well tenant to make a representation in the meantime, my lord.
As regards this entry and exits, as the deputy commissioner has said that
Status quo as on dates will be maintained.
as regards specific to that.
Specific. Yeah.
Yes, Mr. Talulda.
That can be done. Individual time I'll get the instruction.
Heard Mr. Didas, learned senior counsel, assisted by Mr. M.H. Loskar, learned counsel for the petitioner, M.S.G. Hajorika, learned standing counsel, Revenue and Disaster Management Department for the respondent number 1, and Mr. B.J. Talukdar, learned senior counsel, assisted by Mr.
KD Sharma.
K.D. Sharma, learned counsel for the respondent number 2 and 3. First of all. issue notice returnable on switch. 5th April. As any other parties, private parties?
Private parties, I think.
No, 2, 3, and 4.
2, 3, and 4.
As the respondents are duly represented by the respective councils, the issuance of formal notice is dispensed with. However, Mr. Law Scholar and counsel for the petitioners also have requisite number so and so within 2 working days. Full stop. In the course of previous deliberation, it was projected on behalf of the petitioner that due to the demolition stroke eviction process, the entry and exit to the petitioner's building, when the petitioner runs a diagnostic center, has become difficult. Full stop. Considering the fact that the petitioner runs a diagnostic center in the said building, and the same caters to the public, this court asked the respondents, more particularly the respondent number 2, to place instructions as to whether any obstruction, as to whether there is any obstruction in the entry and exit from the public road to the petitioner's diagnostic center. First of all, on the previous date of listing, that is on 23/2/2024, the respondent number 2, by placing 2 number of videographs and 1 number of photograph, had submitted that the entry and exit to the petitioner's diagnostic center has not been hampered and it is functioning normally. Full stop. Mr. Das, as senior counsel for the petitioner, has not disputed such position as regards the diagnostic center, petitioner's diagnostic center. Full stop. In such view of the matter, the parties shall maintain status quo as regards the matter of entry and exit from the public road to the petitioner's diagnostic center till the returnable date.
Right.
If as regards any matter relating to obstruction of entry and exit to other commercial establishments in the building and the reference, it is the aggrieved persons, since the aggrieved persons, since the persons concerned with those commercial establishments are not before this court, the petitioner, this court is does not want to advert on that issue at this stage.
Right.
At this stage.
Yeah, right. No problem.
Item 7.
Deeply approved.
Yes, Mr. Bora.
Since I was directed to obtain instructions.
Yes, because despite his absence.
But I have not received any instructions.
Okay. We'll issue notice then.
Yes, Lordship.
Proceed.
Your name?
SK Sinha.
SK?
SK Sinha.
Sinha.
SNG.
Heard Mr. SK Sinha, Learned Counsel for the petitioner. And Mr. DC Bora, Learned Central Government Counsel for all the respondents?
All the respondents.
All the respondents.
Lordship, some protection may be granted, Lordship.
Huh?
Some protection may be granted.
No. We don't know.
After filing of the
Without knowing, we cannot. This is not a situation. The petitioner is aggrieved by issuance of lookout circulars against the petitioner holding passport number if his number put us. Three passports.
Three passports.
Issue notice returnable on.
5-4.
Despite your absence, I asked Mr. Bora on the earlier date, please take instruction. As Mr. Bora had appeared, accepted. No formal notice. Extra copies within 2 working days. Pendency of the writ petition. It is observed that pendency of the writ petition shall not be a bar for the respondent authorities to consider the matter of to consider the grievance of the petitioners in accordance with law.
Obliged, Lordship. Item number 8.
Madam, your appeal is pending. And I have examined that Regulation 10 of the Assam Board of Revenue Regulation has provided the power to the Board of Revenue to pass stay order, interim order, everything. When a parallel proceeding is pending, and that forum has the power to stay, why should we run a parallel proceeding here? I was not sure on the previous date whether the Board of Revenue has a power to stay. Have you got my point? Now, if that board is having the power to stay, and already a proceeding is pending at your instance before that board, and more particularly, that board has the power to stay, then why will entertain this writ petition? When you did not go there.
I approached before the.
That we are not.
Filed appeal
We will not allow multifarious proceeding at different forums. I was in doubt on that day whether that board has the power to stay or not. Right. Now I am confirming myself that board has the power to stay. Why should we?
Then I have to approach before the Assam Board of Revenue.
Definitely. Assam Board of Revenue Regulation, 1963. And Regulation 10, stay of execution of order, pending final decision on any appeal or application, the board may direct that the execution of any order against which appeal or application is made be stayed on such condition.
My appeal is pending before the Deputy Commissioner, my lord.
No.
Appeal is pending before the Deputy Commissioner.
Madam, your statement, you are going against your submission statement. Let us see.
Your lordship may kindly see page number 23, annexure 5.
You are not before Revenue Board.
No, my lord, I am before Deputy Commissioner Dhupri.
You preferred appeal under 147.
147.
What the deputy commissioner has passed?
Deputy Commissioner has only issued notice.
Did you move any application before him?
I have interim prayer, but a prayer is not, I have an interim prayer in the appeal, but a prayer is not considered, only issue notice.
Then you move the revenue board. Because it is not such urgent, because it is going on since 2000 when? 2020
2020 order was.
onwards.
But your lordship has on the last occasion directed the state government advocate to take instruction whether any order was passed or not.
Yes, anything was passed.
My lord, the verbal instruction is, my lord, two hearings on 2 dates, hearings were taken place. And a third date is fixed.
Any final order was
No
passed?
final.
No.
I did not get the next date also, my lord. How can I appear?
If you can always go to the.
No, my lord, no,
Circle
they did
officer.
not
It
furnish
is
me any
because-
date also. That is the difficulty, my lord.
Okay, ascertain will dispose of. Ascertain today. What is the next date?
Monday.
She will appear. Because there is no finality reached
Monday.
in respect of the proceeding. Why should we?
Even after that.
Why
after
should we
that order
entertain,
also
keep on
taken-
entertaining this kind of petitions?
Monday. Even after the final order was passed, also they can approach the.
People have started coming to know about the date fixed by circle officer, deputy commissioner. This is the situation now. Get the dates, we will dispose of. Or otherwise, get a date fixed.
Monday. There, Monday.
Today itself, we will dispose of. Yes, I am sure. You will be happy? No final order has been passed. We'll find out the date. You will appear on that day at 10:30.
Lordship
that.
may also fix it.
No, you get that.
I'll get the.
If it's already a date fixed, why should we fix?
Item number 9.
Your Lordship, I am filing this petition challenging the order of the Lok Adalats. I had, there was a maintenance case going on in.
It is a compromise.
It was a compromise in Lok Adalat. Unfortunately, when I signed it, agreement, I was not knowing in other things. What happened? I have got a property in Guwahati. Is valued about 50-60 lakh.
Mr. Counsel.
Yes, sir.
It is not only before a local law. Come to page 25. This is an order passed by the family court also. Because matter was referred to local law. Is it not?
Same day, Lok Adalat order was.
Right. This is page 24. Is there, you have subscribed your signature there?
Yes.
There is no presence of counsel also?
No presence of counsel.
Conciliator?
They are not, counsels are not allowed in the.
Then come to page 25.
25. The case.
You have filed a compromise petition through conciliator, heard both the parties, and then order reflected everything. Page 25.
25. Yes.
Order reflected everything. Now, why? Why will entertain this writ petition? Otherwise.
Yes, Your Lordship, I'll tell the reason. This case 702, that 702 by FCC criminal 702 by 18, it is for maintenance. Where in the plaint, in the case they have lodged in the court, nowhere they have prayed that it is not prayed that they could do mortgage or something, land be transferred in the name of the child. But the point is that the child was adult at that time. When the case was filed, the child was adult.
Mr. Counsel, it is your daughter. Don't say a major, minor, all these things. It is your daughter. And you have agreed. Before the local adalat, thereafter you again appeared before the family court on the same day maybe. Case record put up today before the local adalat. Both the parties are present. Seen the joint compromise petition filed by so and so through conciliator. Heard both the parties. Both the parties have submitted that they have amicably settled their disputes outside the court. As settlement of the, as per settlement, agreed so and so, so and so. So, now, where is the scope of Article 226?
Your Lordship, I have to.
It is settled.
It is.
It is settled.
Agree, the position is this. that
Did you allege fraud?
Fraud, yeah, I was.
Did you allege fraud?
I am not alleging fraud, but I was put under pressure over that day. It was same day the local said and same day order was given.
I am not entering this petition.
Your Lordship,
J-A-L-O-U-R.
Your Lordship.
L-O-U-R. Jalo.
Your Lordship, kindly listen to me. I am, see, there's the.
Facing difficulties in the subsequent point of time, after you entered this settlement in 2019.
Yes, Your Lordship.
It is not that yesterday you were forced to sign a compromise under force. You immediately have come. You have been sitting over the matter for 4 years. And after 4 years, suddenly you realize that my financial condition is not that good.
No, Your Lordship. I have moved in the court. I moved in the court of held that is still pending, no doubt. But the point is
pending,
that,
then you proceed. This is not a case of rejurisdiction. Hard, Mr.
Your Lordship.
Z.K. Gupta. Z.K. Gupta.
Yes, Your Lordship.
I am not entered.
Your Lordship, kindly listen to me. One last thing. That I am put to so much of pressure. My flat, it is already fetching about 20,000. About 20,000 is rent, which they are enjoying since 2006. And I have got no other property except this property. Now, just like a beggar cannot be be a donor.
Otherwise, you have a duty to maintain your wife and your daughter, and which you have agreed to 4 years back. Now, suddenly, you cannot realize that what I had done before 4 years should not have been done.
It is not suddenly, Your Honor. I have already filed a case for modification of judgment. But in the lower court, they are saying this can be executed only in the high court.
Fraud, you go fraud, establish fraud, but here apparently no fraud.
No, I'm not seeking telling that it is a fraud.
Because your entire rental income is being enjoyed by the respondent.
They are enjoying it.
Petitioner totally, your wife totally ignored your calls. Right? All these things are there. You also married for a second time. Is it not?
Yes. Abusing
the process of the court.
I waited for 11 years.
Abusing the process of the court.
I waited for 11 years.
Hard, Mr. G.K. Gupta. Learned counsel for the petition. The case projected in this petition is as follows. Salini Shyam City. The petitioner and the respondent number. Respondents. Petitioner and the respondent, comma. The only respondent implicated in this state petition, comma, were married on 7/3/1996 at Guwahati as per Islamic rites. And a daughter was born to them on 1/2/2000. The petitioner has stated that the respondent left the company of the petitioner on 23/11/2006. And since that day, the respondent refused to return to her matrimonial home, and all efforts to make her return proved futile. Full stop. The petitioner has stated that he had purchased a flat from his own income and had allowed the respondent to keep the rental income of the flat for her needs. First stop. There is a case of the petitioner that the petitioner waited for about 11 years, expecting that the respondent would return and would live with the petitioner. But the respondent did not return to stay with the petitioner. First off, the petitioner has stated that he had remarried in the year 2017 at Kolkata. First off, pursuant to the petitioner's no divorce also.
It's a Muslim.
Pursuant to the petitioner's
It is Muslim.
marriage,
Yeah,
second marriage,
He is
the respondent instituted a proceeding, a maintenance proceeding under section 125, Code of Criminal Procedure, 1973, before the learned family court.
They are Muslim.
But we are not living in that old age. We are living in 2020s.
After 11 years of wait, Your Honor, I have to do that.
Family court. Seeking family court, Kamrup at Guwahati. And the said application has been registered and numbered as F C within bracket CRL bracket close number 702/2018, wherein the petitioner was the opposite party, sole opposite party. When the petitioner, when the said case, FC so and so was pending before the Court of Learned Principal Judge Family Court, Kamrup Metro, the matter was referred to the Lok Adalat, scheduled on 9/3/2019. Post of para. When the before the Lok Adalat held on 9/3/2019, both the petitioner and the respondent appeared, and it was submitted that they had agreed for a compromise. Full stop. As per the order, Legal Service Authorities Act, the Lok Adalat in the order dated 9/3/2019 of the Lok Adalat, it had been recorded that the petitioner had agreed to transfer the property within bracket flat situated at Adgaon, Guwahati in the name of his only daughter, Simran Ahmed. Full stop. The order had also recorded that the petitioner had also agreed to transfer rupees 20,000 per month as monthly maintenance to the petitioner and his and their daughter. Full stop. It was whose signature is this?
This is mine.
Huh?
Mine.
Your
This
page 24?
24, yes.
Four handwritings?
Mine means the petitioner.
It was further recorded that the amount would be transferred to the account of the respondent as per the details to be given by the respondent, as per the bank details given by the respondent. Full stop. Para. The petitioner and the respondent also appeared before the learned Principal Judge Family Court number 1, Kamrup, Guwahati on 9/3/2019. Full stop. By appearing before the learned Principal Judge Family Court in person, the joint compromise petition entered into by the petitioner and the respondent through the conciliator were presented before the learned Principal Judge Family Court. Full stop. Learned Principal Judge Family Court, after perusal, peruse the same. Full stop. It was submitted by the petitioner. Full stop. The order of the learned Principal Judge Family Court, dated 9/3/2019, has reflected that both the petitioner and the respondent had submitted before the court that they had amicably settled their disputes outside the court. And as per the settlement, the petitioner had agreed to transfer his landed property situated at Andgaon in Guwahati in the name of his daughter, Miss Simran Ahmed, and had also agreed to deposit a sum of rupees 20,000 per month to the petitioner and her child directly in the bank account of the per month to the respondent and their child directly in the bank account of the respondent, and the respondent had accepted the proposal. Full stop. The learned Principal Judge Family Court had accordingly directed the petitioner to pay maintenance at rupees 20,000 per month to the petitioner and their daughter with effect from 9/3/2019. So the case was accordingly disposed of on compromise. Full stop. Para. Yes, now it is. What is your case?
My submission is, Your Lordship, that this is the only property which is fetching a monthly rent of around 20,000 per month. And I was under the impression that it's for 20,000 rent, whatever they are getting, that will be set off from the rental income they are getting. Now, even now, I am willing to pay the entire property in the name of both mother and daughter. I have got nothing to say about that. But I want to get free from this monthly payment every month. Once for all, I want to settle it. I am ready to transfer this property in the name of the mother and daughter, or in the name of the daughter, whatever they say.
Approach the family court for that.
Your Lordship,
we are not husband-wife dispute. We want the legality and validity of the
and now
local order.
Now one more thing as well. The daughter is already a dentist. She's a dentist. then she is not entitled for any maintenance as such. And this was the 20,000 mark for mother and daughter both. She is a dentist now.
It is a legal service authority. Legal service authority. Legal service authority, right? As per section 22E. Of the Legal Service Authorities Act. No, section 21 of the Legal Service Authorities Act. Every award of the Lok Adalat shall be deemed to be a decree of a civil court, or, as the case may be, an order of any other court. And where a compromise or settlement has been arrived at, by a Lok Adalat in a case referred to it under subsection 1 of section 20. Every award made by a Lok Adalat shall be final and binding on all the parties to the dispute, and no appeal lies to any court against the award. Full stop. A Lok Adalat determines a reference on the basis of a compromise or settlement between the parties at its instance and puts its seal of confirmation by making an award in terms of the compromise or settlement. Full stop. Para. It is true that against an award of the Lok Adalat, a writ petition under 226 of the Constitution of India can be filed, but such writ petition can be filed on very limited grounds, as has been held by a 3 judges bench of the Honorable Supreme Court of India in State of Punjab and another versus Jalor Singh and others, reported in 2008 to SSC 660. Full stop. For instance, if a party alleges a ground like fraud, then the writ petition, maintenance of the writ petition can be examined on the basis of the convincing materials based on record. Full stop. Para. In the case in hand, the petitioner has averred that the petitioner had purchased the flat, flat of 750 square feet size way back in 2002, and the same was rented out in 2006. Correct?
2006, 2002 it was, and 2006 it was rented out.
It was the petitioner had allowed the respondent to collect and keep the rental income from the flat and till date, it is the respondent who has been enjoying the rental income of the flat. Full stop. The petitioner has raised a grievance that the respondent, after the respondent left his company, the respondent did not return to the matrimonial house. Full stop. It was after waiting for a long 11 years, the petitioner had tied the nuptial and UPTIL knot again for the second time in the year 2017. Full stop. The petitioner has not raised any contention that the compromise arrived at in the course of the maintenance case, maintenance proceeding, FC criminal 702/2018 before the local adult was vitiated by any factor. Full stop. The petitioner has averred that the petitioner was paying rupees 20,000 per month as maintenance regularly till he defaulted on and from February 2020 as he lost his job in January 2020. Full stop. Though after COVID pandemic subsided, the petitioner joined a new job in May 2021. So the petitioner has now averred. Petitioner has now contended that the respondent was barred from representing their daughter as she was already a major at the time of filing the petition, compromise petition. Therefore, the amount of rupees 20,000 as maintenance in favor of the respondent and the daughter was against the provision of law. Full stop. The petitioner has also stated that he was under psychological pressure to arrive at a settlement before the conciliator on 9/3/2019. Full stop. Such contention cannot be countenanced in view of the fact that the petitioner has waited for about 4 years since since 2019 to raise such contention after 4 years. Full stop. The other grounds agitated by the petitioner in this petition does not fall within the ambit of exceptional cases under which a writ petition under Article 226 of the Constitution of India can be entertained against an award passed by the Lok Adalat and an order passed by the learned family court on the basis of such compromise arrived at the Lok Adalat. Full stop. In such view of the matter, the writ petition is not entertained. Accordingly, the same is dismissed. Instruction is available.
Yes.
Ah,
It is on 11th of March, the 3rd.
11th of March. Third MSS Royal and Council for the petitioner G. Hazarika Lions Pending Council Revenue Department for Respondent number 1 and Mr. S. Borua. Learned Junior Government Advocate Assam for the Respondent number 2.
234.
Oh, 226. 224.
Deputy Registrar.
224. We have already reflected your grievance in the previous order. I got to liquidate. Second pattern. Mr. Borua, Learned Junior Government Advocate Assam, was asked to obtain instruction on 23 to 2024. One, question as to whether the circle officer so-and-so pass any final order in case number so-and-so and if yes, as to why a certified copy has not been supplied to the petition despite her application dated 24/1/2020. So Mr. Borua has submitted upon receipt of instruction that no final order in case number so-and-so has been passed by the circle officer Vilahipara Revenue Circle till date. And the case is still pending. Post of the next date of the case is fixed on 11/3/2024. Post of. As the case number so-and-so is pending and no final decision has been passed till date, it appears that there is no cause of action for the petitioner to maintain this writ petition. Full stop. The petitioner shall appear before in the proceedings of case number so-and-so scheduled on 11/3/2024 at the office of the circle officer, Vilahipara Revenue Circle at 10:30 a.m. on that day for the purpose of pursuing her cause in the state proceedings with the aforesaid observation from the purpose of this order disposes of the writ petition.
Item number 10.
Lots of matter pertaining to free, right to free and compulsory health care and services, your lordship. As your lordship very much aware, our government has adopted number of policy scheme also for.
You want mini public health center?
Yes, lordship.
At your place?
Yes, lordship.
Whether we can issue mandamus?
Lordship, as because your lordship.
You are espousing public cause.
Lordship. It's a bit PL maybe, but.
We
Lordship,
cannot issue mandamus. It can be within the contour of a PIL.
Lordship, I know, but I'm. But
That is, you espouse. So many petitions are there.
Lordship.
You can espouse the cause in a PIL. We cannot issue a mandamus that set up a PHC here, everywhere.
Lordship.
If suppose thousands of this kind of petitions are filed, can we go on issuing mandamus, set up here, set up there, set up there? They have
Lordship, but
resources, financial resources, but that resources is to be utilized according to the needs of the public. We can do.
Lordship can so much depend.
I think it is a public cause.
Lordship, but our case is that your lordship, maybe it's public interest, but the application submitted before the EM through EM, executive member of
It is
the
BTC,
BTC
Lord.
Council, your lordship. And this application forwarded through District Legal Services Authority of Kokrajhar. In this regard, your lordship, minor source.
I don't know, we can issue notice at this stage,
Lordship.
maximum, otherwise we don't find maintainability of this.
Lordship.
For issuing mandamus to set up a public health center at a particular place. Tomorrow somebody will come, set up a medical college here, set up an AIMS here.
Lordship, yes.
We cannot go on. Hard, Mr. SI, I can learn Castle for a petition. MS petitioners, MS S. Sharma,
1, 3, and 5.
Standing Council, Health and Family Welfare Department for the respondent number 1,
3 and 5.
and 5.
Yes, I appear for respondent 2 year.
MS
ADAS.
ADAS, Land Standing Council,
Yes, sir.
National Health Mission for the respondent number
2.
2.
Yes.
Any BTC?
BTC is not reflected in the cause
Okay.
list.
Issue notice returnable in 4 weeks. As MS Sharma and MS Das has entered appearance and accepted notice on behalf of the so-and-so respectively, no formal notice is required. Extra copies within 2 working days. The petitioner, counsel for the petitioner shall serve a copy of the writ petition along with annexer to the Land Standing Council BTC for the respondent number 4 within 2 working days.
Item number 11.
My lord,
No cause of action.
no, my lord, from my lord, 14 to 2023, my lord, page 64, my lord. My lord, our arbitrary appeal is pending from that, my lord, 14 to no, my lord. They already abolished by my lord. Annexer 8, page 66, my lord.
So,
So
your
my
grievance
lord,
is?
grievance is that, my lord, paras pair C, my lord, in my now, my lord.
Pair
my-
C.
My lord. Conclude the arbitration proceeding within a short period, my.
Yes, MS Gora.
Lordship,
Your lordship.
already arbitrator has been appointed. my lord.
I have seen. So that pair, we didn't, because of that, already, my lord, the hearing is
There is no
completed.
cause of action. Already arbitrator appointed.
But but our case is concerned is not, my lord.
Which district?
The Sunitpur, my lord.
It is there.
Yes,
Sunitpur.
yes, sir.
Sunitpur is there, my lord, but just now I am seeing, my lord. But my case may be completed.
Sunitpur is there.
Yes, my lord. So, my lord. Pair C,
You
my lord.
will appear before the
Yes, my lord.
arbitrator
Arbitrator.
and pursue your case.
No, my lord, your lordship may be directed to complete by within a period, short period.
Oh no, yesterday Supreme Court has directed that High Court don't direct other authorities to complete within a specific period.
But take my
no.
take my case, my lord, by the arbitrator as soon as possible because of that.
Petitioner will appeal.
Already, my lord, page 64. my
Heard
lord.
Mr. Enbora, Counsel for the petitioner, petitioners. Mr. MS N. Borule, Learned Junior Revenue, Standing Council Revenue and Disaster Management Department for the respondent number 1 and 2. Mr. S. Burua, Learned Junior Government Advocate Assam for the respondent number 3, 4, 5.
I am appearing for 6.
And Mr. MS N. Bora, R. Bora, Learned Standing Council, National Highway Authority of India for the respondent number 6. And Mr. R. K. Talukdar,
For 7 and 8, my lord.
Learned Standing Council, National Highway and Infrastructure Development Corporation Limited for the respondent number 7 and 8. Full stop. The petitioners 18 in number have preferred this writ petition stating that they have a common cause of action. Full stop. It is a case of the petitioners that their parcels of land have been acquired by an acquisition process initiated under the provisions of the National Highways Act 1956 for the purpose of a project, comma, what is the project? Anywhere? Is it mentioned?
No, minor.
Where is 3A?
Connection with
3A,
construction.
3A or 3B, where is that?
Connection, construction,
Project,
4 lane,
project.
space 21 would be.
Place 21.
Yes, my lord.
Hmm.
My lord, so dated 4/12/2020 in connection with construction of 4 laning
Project,
NH in
comma, construction of 4 laning. 4 laning of National Highway in Sunitpur district.
My
Full stop. In the process of such acquisition, comma, different amounts of compensation are shown to have been assessed in the estimate prepared under section 3Z of the National Highways Act 1956 in favor of the petitioners. Full stop. As the petitioners' parcels of land are shown valuation at rupees 1 lakh, 13 lakh per bigha, comma, the petitioners are aggrieved on the premise that the present market value of those parcels of land are much higher. 13 lakh, correct?
13 lakh, but they given only 1,15,000.
Okay. Assessed at 1,15,000.
My lord.
Were much higher at rupees 13 lakh per bigha.
My lord.
1,15,000 they have given.
They have given.
Agreed by lesser amount of compensation on the basis of such lesser valuation of the petitioner's parcels of land in the said acquisition process, comma, the petitioners have preferred an application under section 3Z within bracket 5 of the National Highways Act before the arbitrator, before the then Commissioner, North Assam Division, Tezpur, who was appointed as arbitrator by the central government under Section 3G5 of the National Highways Act, 1956. Full stop. It is the case of the petitioners that their application before the arbitrator has been registered and numbered as appeal case number 18/2022. Full stop. As during the subsequent period, the post of commissioner of divisions in Assam, including the office of the Commissioner North Assam Division, came to be abolished
on 17/2/2020.
by notification dated
17/7/2020.
17/7/2023 of the
Divisional Commissioner
of the
page 66, my lord.
of the
First paragraph, my lord. General Administration Department.
of the General Administration Department,
Right.
Government of Assam. The petitioners have preferred that have approached this court on the ground that in the absence of arbitrator, there will be delay in disposal of their application, appeal case number 18/2022. Full stop. We can dispose of similar terms, notification, para 8, instead of Golaghat, Sonitpur. Para 9 not liখিব, with the appointment of the arbitrator in respect of the National Highway 37 লিখিব নালাগে, project within the district of Sonitpur, the common grievance raised by the petitioners herein is found to be effectively redressed. In order to facilitate the arbitrator so appointed, to deal with the arbitration proceedings related to the applications of the petitioners, the state respondent authorities shall transmit the records of the concerned arbitration case of the petitioner herein, who have already submitted their application seeking enhancement stroke reassessment of the compensation amount before the office of the erstwhile Divisional Commissioner North Assam, to the office of the arbitrator within a period of 4 weeks from today. On receipt of the records of the arbitration case of the petitioner, the arbitrator so appointed, shall proceed to consider and dispose of the applications as expeditiously as possible, preferably within a period of 6 months from the date of receipt of the records.
6 months because already hearing is completed, my lord. Only joint verification at page 64, my lord.
We don't know. With the observations made and direction given about this, the repetition is disposed of. No cost.
4 months.
No, consistent. I am consistent. 6 months, 6 months.
Much or less.
Do you have the notification or not?
No,
Okay.
I'll give.
Talukdar, provide a notification to him.
much or less. Much of it.
It is number 12.
Your Lordship, on behalf of my senior Mr. Ahmad, in this matter may be taken up.
What is your grievance? Yes, Mr. Urwa.
With regard to compensation of the legal service
Ah?
authority.
Again, it is pending before that
Legal
authority.
service.
Now he has come running. What to do?
Like, district and state legal service authority are being represented by
Where is your that notification?
15/7/14.
That victim compensation scheme,
Yes.
very illegible. Amar ase niki victim compensation scheme? I think they have a mandate, Mr.
Yes.
Borua.
Yes, yes.
They have a mandate to decide this kind of application within a stipulated period.
Stipulated period.
Find out from this, be very illegible.
No type copy of.
Okay.
I don't know how come this kind of pages are being approved by the filing section because
We also don't know.
they haven't gone for any type copy of. Sal copy nahi hai.
Rule 5, though it is illegible, Mr. Borua.
Yes, but
Yes, 27.
Yes.
First, second, third, fourth, fifth, sixth, seventh, eighth, ninth. Ninth line. This scheme has a mandate that DLCA
About
should
compensation, 2
decide
months.
about compensation within 2 months.
2 months.
Since it is already so and so, we can only request.
Yes.
We can dispose of.
Yes.
Yes. Let them dispose of. Heard, Mr. A. Rahman. Learned counsel for the petitioner. And Mr. S. Borua. Learned Junior Government Advocate Assam for the respond number 1, 2, 4, 5, 6.
Commissioner of this is 2 is for finance.
Okay. 1, 4,
4,
5,
5,
6.
6.
Anybody else?
No.
The case projected by the petitioner in the instant writ petition filed under Article 226 of the Constitution of India is, in brief, is that the petitioner's son, Rafiqul Islam, was severely assaulted on 23/4/2021, which led to his instantaneous death on the spot. Full stop. In connection with the said incident, a crime case, Gwalpara Police Station case number 271/2021. Sarsi submitted? Sarsi submitted? You don't have any idea? Mr. Burua, can you find out from the petition? For the offenses under section 120B, 325, 340, 120B, 341, 305, 325, comma, Indian Penal Code. And investigation into the case was started immediately thereafter. Full stop. Seeking compensation. Oh no, full stop. The postmortem examination of the deceased was performed at the civil hospital Gwalpara on 24/4/2021. Full stop. Seeking compensation under the Assam Victim Compensation Scheme 2012. It is stated that seeking compensation, the petitioner submitted an application before the District Legal Services Authority Gwalpara on 17/11/2021, claiming compensation of rupees 5 lakh, comma, as notified by the political within bracket A department, Government of Assam, by the notification bearing number page 33 dated 1/2/2019. Full stop. Any cases registered?
Gwalpara PS case 27.
No, that is okay.
Yes.
DLSA.
No. No, no mention.
The petitioner has approached this court by the present writ petition on the premise that the District Legal Services Authority Gwalpara has not disposed of the application submitted by the petitioner for grant of compensation under the Assam Victim Compensation Scheme 2012 till date. So stop. Para. The Assam Victim Compensation Scheme, 2012 has been framed in exercise of the powers conferred by Section 357A of the Code of Criminal Procedure 1973 to provide fund for the purpose of compensation to the victim or his/her dependents who have suffered loss or injury as a result of a crime, and who require rehabilitation. Full stop. The scheme, the Assam Victims Compensation Scheme 2012 has been notified by the Political Department Government of Assam by the notification bearing number PLA 357/2010/123 dated 18/10/2012, and the same was published in the Assam Gazette on 20/10/2012. Full stop. Sub clause 5 of clause 5 of the Assam Victim Compensation Scheme 2012 has entirely provided that not 5, not 5. One. Has entirely provided that the District Legal Services Authority receives any application from any victim or his/her dependents, the said authority is required to examine the case and verify the contents of the claim with regard to the loss or injury caused to the victim and arising out of the reported criminal activity, and may call for any other relevant information necessary in order to determine genuineness. Full stop. After verifying the claim, the District Legal Service Authority shall, after due inquiry, award compensation within 2 months, in accordance with the provisions of the scheme. Full stop. Since the Assam Victim Compensation Scheme has contained a mandate to decide an application within a period of 2 months, and the petitioner has claimed that his application is presently pending before the District Legal Service Authority, Gwalpara, this writ petition is disposed of with the observation that the District Legal Service Authority, Gwalpara, shall consider the application stated to have been submitted by the petitioner as per the provisions of the Assam Victim Compensation Scheme, as expeditiously as possible.
But this application also, again, there's no formal, this is a type copy, it doesn't contains any acknowledgement.
Stated, that is why I have said stated to be. If there is no application, they will dismiss.
If any application.
One thing, my lord, there is a clause 5 of the scheme says that it has to be decided within a period of 2 months.
Clause 1, sub-clause 1. So I have recorded that.
I am.
Number 13.
Lordship, similar case is posted on 6th of March.
On the request of Mr. F.J. Majumdar, Learned Counsel for the petitioner, is the case on 6/3/2024. Yes.
I am for respondent 1, my lord.
Mr. P.S. Pottassetti, the standing Central Government Council for the respondent number 1 is in attendance.
Lordship, it can be posted along with the writ petition number 9.
6th it is listed.
Lordship.
Item 14.
Let here it very short question involved. My lord, the petitioner number 1 to 6 are the owner of the land. 7 to 11 are the purchaser. They applied for permission for sale of the land.
Come to page 41.
In July.
Read.
Your lordship referred to page 31.
31.
Yes. Morigaon, Jila, Morigaon. Moi, Ami, Morigaon.
41, 41.
41.
Yes.
Yes, ma'am. Application acknowledgement. Yes, ma'am.
1, 2, 3, 4, 5,
13,
6,
7,
7, 8 line.
My lord.
7 line, last two word. You may. Seven line, last two word. You
My lord.
may.
My lord, 45. You can call us on so and so.
You cannot call us. You may raise.
I could not
Appeal,
get it.
appeal.
You may raise an appeal at HTT so and so, so and so.
File appeal.
If this service is not delivered.
File appeal. Already you have been informed that 45 days not delivered, you appeal. First you appeal, don't come. Machinery is provided already. Heard Mr. M.S. Sheikh, Learned Counsel for the petitioners and Bordoloi, Standing Counsel Revenue and Disaster Management Department for the response number 1. What you have written? Commissioner of Morigaon District and Mr. S. Burua, Learned Junior Government Advocate Assam for the response number 2. Whom you have made response number 2? It is the case of the petitioners that they have jointly
Yes, my lord.
submitted an application seeking the public service, composite land sale transfer, unquote. Before the competent authorities in Morigaon district by submitting an application online on 13/7/2023. And the said application was duly acknowledged, provide acknowledgement number, page 41, dated 13/7/2023. Full stop. Did you track or not?
My lord.
Did you track your application or not?
Yes, my lord.
You tracked in
First
the
thing.
online
Yes.
portal?
Yes, my lord.
Or any status?
My lord, status, they said that it is pending.
You should have enclosed it
My lord.
because it shows, because I have tracked once. Date to date.
My lord.
Date to date, how it is processed, it is shown in the portal.
I have not.
I had to avail the service once. That's why I know. Correct. The service, composite land sale transfer is a service, is a notified public service under the provisions of the Assam Right to Public Services Act, 2012. Full stop. As the petitioners have not received any communication as regards disposal of their application for composite land sale transfer submitted on 13/7/2023, the petitioners have approached this court by the present writ petition with the prayer seeking a direction to the respondent authorities, comma, more particularly, comma, the respondent number 2 to allow to process and allow the application for composite land sale transfer, full stop, para. From the acknowledgement, application acknowledgement dated 13/7/2023, generated with acknowledgement number so and so, comma, it has been stipulated that if the service is not delivered within a period of 15 days, comma, the petitioner
45 days.
45 days, the petitioners, the applicants can file an appeal at the portal, comma, early class. Full stop. It is settled position of law when a appeal, statutory appeal is provided for, comma, a writ petition under Article 27 is not to be entered into it unless the said remedy of appeal is exhausted by the petitioners. Full stop. In such view of the matter, comma, this writ petition is disposed of with the observation that the petitioner shall avail the remedy of appeal against the grievance of non-disposal of their application for notified public service, comma, composite land sale transfer before the appropriate appellate authority for disposal of the appeal appropriate authority. Full stop. If the petitioner is aggrieved after preferring an appeal due to comma, the petitioners shall avail the appropriate remedy permissible under the law. Okay.
May I please the Lordship? Lordship, I am the proprietor of Lifeline Ultrasonography Center as well as doctor cum sonologist. So my clinic is presently situated at Duburi Jagalar. Due to some unavoidable circumstances, I made representation in several occasions to the appropriate authority for issuing an order to shift my clinic. But no response is given till today. My representation will be
This presentation may disposed of.
representation dated 27/1/24.
Which page?
Page 14 and another page 16. Recent.
You want to shift to Sapor Bazar?
Chapor, this is within the district of Duburi. Chapor Bazar, this is my native place.
What is page 13 then?
Page 13.
You had earlier shifted.
No. First of all, it was at Hachingimari. Thereafter, I shifted to Duburi Jogalar Park.
Now again you want to shift.
I went to Manila, now I am settled at my own place.
Heard Mr.
ATM Hussain.
ATM Hussain, learned counsel for the petition. Mr. Borua, S. Borua, Junior Government Advocate of some for the response number 1, MS and 5, and MS S. Sharma, learned standing counsel, Health and Family Welfare Department for the response number 2,
2, 3, and 4.
4, and 5, 2, 3, and
2, 3,
4.
and 4.
Full stop. The petitioner has stated that he is a doctor by profession and also the proprietor of one ultrasonography center, which is presently situated at Line Road, Jhograpar, District, Dhubri. Full stop. It is the case of the petitioner that Jhograpar Part 1, due to certain unavoidable situations, the petitioner is desiring to shift the ultrasonography center to his native place at Sapor Bajar, which is within the district of Dhubri. Full stop. It is submitted that the petitioner requesting permission to shift the ultrasonography center from its present place at Hatsingmari, Jhograpar, Part 1, to Chapor Bajar, has submitted a number of representations on 29/12/2023, 27/1/2024, and 5/2/2024 respectively before the respondent number
4, Lordship.
4.
4.
Stop. As the said representations have not submitting that the said representations have not been considered by the respondent number 4 till date, the petitioner has to approach this court by the instant petition seeking inter alia direction to the said respondent to consider the said representations. Post of MS Sharma, learned standing counsel, Health and Family Welfare Department, has submitted that since the petitioner has stated that the representations are pending for consideration before the respondent number 4 till date, that this petition can be disposed of with a direction to the respondent number 4 to take the representations of the petitioner, stated to have been submitted before the respondent number 4, to consider and dispose of the same by way of a speaking order.
Yes.
Full stop. Mr. Hussain, learned counsel for the petitioner, has agreed to the said submission advanced by MS Sharma. Full stop. In view of the above in view of the consensus, broad consensus arrived at by the learned counsel for the parties in the aforementioned manner, this court is of the considered view that instead of keeping this writ petition pending, this writ petition can be disposed of at a direction to the respondent number 4, before whom the representations stated to have been submitted by the petitioner, comma, are pending, comma, to consider and dispose of the same by way of a speaking order in accordance with law. Full stop. It is observed that the such speaking order shall be passed within a period of 1 month from the date of receipt of a certified copy of this order, and the decision arrived at by the respondent of court shall be communicated to the petitioner thereafter. Full stop. It is however made clear that the respondent of court shall consider. Now, this court has not made any objection as regards the merits of the claim of the petitioner for shifting of the sonography center from the present place to the intended place. This order disposes of the petition.
Item 16.
The same matter already.
Same matter?
Yes, my lord.
How many are coming?
In the same area, my lord. Allotment letter given in the year 98 and mutated also.
H. Das, petitioner, Z. Hajorika, Revenue 1 and 2. Oh, N. Bodoloi, Revenue 1 and 2. S. Borua, 3, 4, 5, 6, 7. 1 bigha 3 Katha.
Yes, my lord.
29/2000, 1998.
98.
Okay, so I will change code.
Item 17.
May it please your lordship. My lord, the petitioner is challenging the levy of service tax as the same is exempted under mega exemption notification. And my lord, similar matters are pending before this honorable court that your lordship will find at page 140, my lord. Same issue is pending adjudication before page 140, my lord. And 141 it was passed by this honorable court, my lord. More than, my lord, 25 or 30 cases are pending.
Same.
Same.
Your lordship has passed one order, section 86 of Finance Act.
It will be because, my lord, since this honorable court is adjudicating the same issue, my lord, in my humble from same order, my entry protection.
Similar order I have passed.
My lord.
Let's start.
My lord, but the issue pending before this honorable court.
You visited before other court.
My lord, that's why, my lord, this honorable FX court also said, my lord, similar treatment will be given.
So similar treatment to, if it is to be given, then I'll give similar treatment.
Same
as passed by this court.
My lord, same, my lord, same issue, my lord, two mega exemption certificate.
Okay, let it be the next week.
Next week.
On the request of Mr. A. Goel and counsel for the petitioner, is the case in the next week. Mr. S.C. Kyle and a standing counsel GST is in attendance.
Deeply obliged. May I know the name of the order passed by this honorable court?
Mr. Kyle, why I don't know.
Deeply obliged. I will, my lord, try to apprise your lordship.
Item 18.
No, please, lordship.
Brothers.
No, please, brothers.
Where the order? Where is the order? Earlier order.
Earlier order is there.
Yes, Mr. Talukdar.
Similar.
Their brothers have come earlier. One brother.
Well, a portion.
Same DAG number.
Same. Not same DAG number, it's a different DAG number. Different DAG number adjacent to the same plot.
How can it be? Serial number 74, if I remember.
Yeah, serial number 74. is-
Same.
No, now it's a serial number.
Your what? What is your name?
Ananta Kumar Bora and Pokhanta Kumar Bora. Serial number 7 and 15.
7
and 15, page number 34.
What is the main one?
It's page
Come
number
to page 36.
Page 36.
Where is your 7 and 17?
It's just below. 7 is
Which page?
Seven Pokhanta Kumar Bora and 15.
Where is that in page 35 onwards? In page 36.
In page 36.
Where is serial number 7?
In the column name of the Patadars and below serial number 69.
Mark it here.
If it's serial number
Mark it by
69.
pencil.
In page number 34.
I will not go through a magnifying glass. Mark it.
In page number 34, it's
I'll not be able to read.
page number 34 is the type code.
Mark it by pencil. Take this pencil. Micro mini words I cannot read. Pencil will read you. Pencil will do. Get a lock now. Mr. Talder, have you been able to read?
I cannot read this.
You
but,
cannot read.
I'll need a magnifying glass.
Yes.
probably.
I don't have any magnifying glass here. $68, $69. Bottom.
Relevant portion is typed in page number 34.
69.
69.
See, Mr. Counsel, other case was non-service of notice. Here is a service of notice.
Yes, Lordship.
Page 31.
Yes, Lordship.
So,
Page 31, there is no.
you were put to notice.
Yeah, we have put to notice.
That was a case of non-service of notice.
But
Is
they
it
have not specified what amount of land is acquired by us in page number. Lordship, kindly see page number 24. Is the Jamabandi, wherein my name has been reflected. The applicant number, petitioner number 2 has 3 plots. 2 on his own name and 1 inherited from his father, along with petitioner number 1.
Now, what is your letter 17-8?
Lordship, we have filed two representation before.
Which one? Where is that?
Page number 38 and 40
38?
and 40. 38 is the petitioner number 1 representation and 40 is the petitioner number 2's representation before the concerned circle officer. And in page number 39, the paragraph number 4. I humbly request you to kind enough to specify and earmark the area of land to be acquired from me.
How much land you both the brothers have?
We both the brothers have
Together?
paragraph number 2, page number 8, 1 bigha 1 katha.
1 bigha 1 katha.
Yes, Lordship.
And out of that 2 katha, 8 lessa
Total land
are in
is,
the process of acquisition.
total land in Dag number is 2 bigha 4 katha 18 lessas.
2
bigha 4 katha 18 letters.
Paragraph?
In page number 24, the Jamabanti shows the total land in Dag.
No, as per paragraph 2, 1 bigha 1 katha.
1 bigha 1 katha. We joint owners. We are the joint owners.
Joint owners. Out of 1 bigha 1 katha, 2 katha, 8 lessa are sought to be acquired. As per your page 38.
Yeah.
Yes.
But
as per your page 38
as
representation.
notification, there are other patadas also.
Don't say about other patadas. You say your case.
In this Dag, there are other patadas also. But they have not earmarked they have not specified the area of land which is to be acquired from me and from my brother.
No, you two brothers, how much land you have?
We both have 1 bigha 1 bigha 1
Together.
together.
And in the list, how much area of yours are sought to be acquired? 2 kathas, 8 lessas.
2 katha 8 lessas.
2 kathas, 8 lessas. You want the proper identification of that 2 kathas, 8 lessas.
8 lessas.
That is all.
Yes. That will have to be determined. Will have to be determined.
Their representations are pending.
We'll consider that. We'll consider.
You identify
Well,
by causing a field inspection,
well,
demarcate the area,
well,
then they will be able to make protest if required.
well.
Heard, Mr.
S.K. Bhattacharya.
S.K. Bhattacharya,
Can we-
Learned Counsel for the petitioner. Then only thereafter you process further.
Well.
Mr. Calder, you will be appearing for whom?
2 and 3.
2 and 3. For the petitioners and Borderland. Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. And Mr. B.J. Calder, Learned Senior Counsel, assisted by Mr. P.K. Medhi, Learned Counsel for the respondent number 2 and 3. Full stop. The state respondents. Sorry, the two petitioners herein are brothers and joint owners and recorded patadas of a plot of land measuring 1 bigha 1 katha, covered by paragraph 2, Dag number 713 and KP Patta number 123, situated at Revenue Village, Gotonga, Kadol, Moja, Holeswar, Hodor Revenue Circle, Tezpur, District Shonitpur. subject plot. Full stop. The petitioner has have approached this court by the instant writ petition. After their names are reflected in an order published under Section 3(1), read with Rule 4, 3(1) of the Assam Requisition, Assam Requisition and Land within bracket Requisition and Acquisition Act 1964, read with Rule 4, framed under the said Act, which was published ordering Form B in the Assam Tribune in its issue dated 15/9/2022. Full stop. As per the said order, comma, the petitioners, 2 kathas, as per the said one, a plot of an area of land measuring 2 kathas 8 lessas out of the subject plot have been sought to be brought, have been brought under the land acquisition process registered as LA case number 1/2022. Post of para. The projected case of the petitioner is that the respondent authorities have not yet specified and earmarked the area of land measuring 2 kathas 8 lessas out of the subject plot, comma, which has been brought under the land acquisition process of LA case number 1/2022. Full stop. The petitioners have stated that they have approached this court by the present writ petition as their 2 representations submitted before the respondent number 3 on 17/8/2023 have not been disposed of till date. Full stop. Para. By the said 2 representations which are seen to have been received by the office of the respondent number 3 on 17/8/2023 and the seal and signature, comma. The petitioners have stated that the area of land measuring 2 kathas 8 lessas out of the, which is part of the subject plot, have not been specified and earmarked by the respondent authorities before publication of the notice, before publication of the order in Form B in the newspaper on 15/9/2022. Full stop. As the petitioner, as the said area of land has not yet been demarcated, specified and earmarked, comma, the petitioners are in darkness to as to which part of the area of the subject plot is to be vacated. First of the petitioner has further represented that the petitioners has not been provided with any information as regards the amount of compensation stroke award stroke zirat the petitioner will be paid for acquisition of the area of land measuring 2 kathas 8 lasas. First of the petitioner have thus preferred this petition seeking entirely a direction to the respondent authorities, comma, more particularly the respondent number 3 to inform the petitioner to specify and earmark the area of land measuring 2 kathas 8 lasas out of the subject plot and to inform about the petitioners the amount of compensation award stroke zirat to be paid in the process of such land acquisition. First of Mr. Talukdar, learned senior counsel, appearing for the respondent number 2 and 3 has submitted that since the representations dated 17/8/2023 are stated to be pending, comma, and this petition can be disposed of with a direction to the respondent number 2 and 3, the respondent authorities, more particularly respondent number 3, to proceed for specifying and earmarking the area of land measuring 2 kathas 8 lasas out of the subject plot, comma, which are sought to be acquired in connection with land LA case number 1 of 2022. Full stop. In view of the Mr. Pottasari, land counsel for the petitioners has endorsed the said submission of Mr. Talukdar. Full stop. In view of the above, in view of the broad consensus arrived at by the learned counsel for the parties, this court is of the considered view that this, instead of keeping this state petition pending, the same can be disposed of with a direction to the respondent authorities, more particularly, comma, the respondent number 3, before whom the petitioners have already submitted representations, comma, to consider the said representations containing the prayer to specify and earmark the area of land measuring 2 kathas 8 lasas out of the subject plot, which are sought to be acquired in connection with LA case number 1/2022. To stop. It is observed that such exercise shall be carried out within a period of 1 month from the date of receipt of a certified copy from the at his office from the petitioners. Full stop. It is further observed that with the there shall not be any further action like demolition, stroke eviction, etc. Prior to completion of the exercise of specifying and earmarking the area of land measuring 2 kathas 8 lasas out of the subject lot. This order disposes of the requisition.
Item 19.
Please, Your Lordship. My lord, petitioner hearing.
First LD.
Yes,
2% order.
2%.
Similar order.
First LD. Heard Mr. M.J. Quadir, learned counsel for the petitioner. You are private or
Private, private, my lord, private counsel.
And Mr. R. Gogoi.
Correspondent
Standing Counsel, Environment and Forest Department for the respondent number one.
only one.
One only.
Only one.
Housing and Urban Affairs, Mr. P. Nayak, learned Standing Counsel, Housing and Urban Affairs Department, GMC, for the respondent number 2 and 6.
2, 3, and 6.
2, 3, and 6.
4 and 5.
Mr. B.J. Talukdar, learned Senior Counsel, assisted by Mr. P.K. Medhi, learned Counsel for the respondent number 4 and 5. Full stop. It is the paragraph 2. The petitioner has averred that he owns and is in possession of a plot of land measuring 3.8, about 3.87 R, covered by tag number 1236 and pattern number 85, situated at village Potasil number 2, Mauza Jalukbari Kamrup Metro. Potasil number situated village Ganeshpara. Petitioner has stated that he is a joint patta holder of the has further stated that his wife also owns a plot of land measuring 3.13 R, covered by tag number 1237 and pattern number 85, at the same location.
Yes.
At the same location. Subject plot number 1 and subject plot number 2. It is a case of the petitioner that he and his wife are desirous of constructing a residential G+2 RCC building on the subject plots jointly by availing loan from financial institutions and by investing their own savings. The petitioner has mentioned that he intends to construct, has submitted that they intend to construct the proposed building by obtaining materials from open market, by paying all necessary taxes. The petitioner, for the purpose of obtaining no objection certificate, has also deposited an amount of rupees 20,923 as building permission fees. But it has been informed to the petitioner that the building permission NOC for construction of the proposed residential G+2 building would not be granted unless the petitioner deposits forest royalty in terms of a decision taken by the Mines and Minerals Department, Government of Assam, contained in communication bearing number PEM 174336/183 dated 2/3/2023. Annexer, green bracket, page 36.
Yes.
Page 36?
Yes.
Para 4. Para 5, issue notice returnable. Para 6. Para 7. Para 8.
Will be tagged with the leading matter 2040-2023.
You provide a list.
Yes,
Number 20.
Interim is there. Interim is there.
Public. Item 20. Or Mr. B. Chetri, Lion Council for the petitioner. Ian Boduloi, Lion Standing Council Revenue and Disaster Management Department for the respondent number 1. R.M. Borua, Lion Council representing Mr. B. Gugoi, Lion Standing Council Finance Department for the respondent number 2. Mr. B.J. Taludar, Lion Senior Council assisted by Mr. P.K. Mehdi, Lion Council for the respondent number 4, 5 and 6. Full stop. Petitioner's son, daughter,
Husband, madam.
husband, Joyram Deuri.
Gayan.
Accident date,
Joyram
Gayan.
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 Gayan,
Yes.
Joyram Gaon. Accident date 2/6/2023. Notification dated 15/11/2024. 14. Issue notice return books. Extra copies.
Item 21. Lordship, I beg to appear virtually in item 21.
Yes.
Lordship, this is similar matter which your Lordship decided for section 168A regarding the force majeure. The issue of show cause notice.
Page 51, Lordship.
Lordship, page 51 is your Lordship's order.
A Kanodia, petitioner, virtual mode, assisted by Mr. Pidas.
Zaid Islam, Lordship.
Zaid Islam. Common Learned Counsel for the petitioner, SC Kyle Learned Standing Counsel, ST for all the respondents. Paragraph 2. Where is the annexer? Annexer?
Lordship, show cause annexure? Show cause?
No. Come to paragraph page 52.
Lordship, I am at page 52, Lordships.
This paragraph 2.
Notification number, Lordships.
It is annexer?
Lordship, and it is annexure 1.
1. And the
Lordship.
demand comes show cause notice.
Lordship demands, it is annexure 2, Lordships.
Page?
Page number 28. Demand come show cause notice, page 20.
Hearing number to change kore dibo. Paragraph 3, same?
Lordships, just 1 point, Lordships.
What is the date of the demand come show cause notice?
Lordship, 30th of January 2024.
30/01/2024. Paragraph 2, a page number here, demand comes show cause notice silo. What is the figure?
Lordship, figures in this case, there are 5 different amounts. Shall I say the consolidated amount, Lordships?
Yes, consolidated.
Lordship, I am giving the consolidated amount. Lordship, the consolidated amount of total tax.
Same thing in
16,16,1628.
1628.
347.
347.
This is the tax amount, Lordships.
Page 53, my underline corridor height, it will replace corridor. Is it ineligible ITC?
Lordship, some ineligible ITC, some late fee.
1 minute.
Lordships.
Ineligible input tax credit, stroke, late fees. Ineligible income tax, input tax credit received from the supplier who did not file their GSTR TB returns. Correct?
Lordships.
And other amounts. Like late fee, etc.
Late fee and tax payment also, Lordship. Some dispute of tax.
Late fee, etc.
Lordships.
What is the financial year?
Financial year 18-19, Lordships.
Same.
Same financial year, Lordships.
Issue notice returnable.
Lordship, this matter is returnable. The earlier matter is returnable on 15th, Lordship.
What is the Allahabad High Court order, annexer?
Lordship, and it is at annexure number 5.
5.
5. Allahabad is 5, Lordship.
Allahabad.
Allahabad, Lordships.
Okay.
Gujarat is annexure
Gujarat
6.
is?
Annexure 6, Lordships.
6. Punjab.
7, Lordships. Annexure 7.
Madras.
Annexure 8, Lordships.
And this court's order.
This
Annexure-
court's order is, Lordship, annexure 9.
Annexure 9, huh? And by annexure 9, huh? Pencil to Musidio, huh? Pencil to Musidio. Page 54. What is the show cause notice date?
Lordship, 30th January 2024 at page number 28.
Okay.
Lordship,
Returnable date.
Lordship, I will file reply
Same. You file.
15th March, Lordships. That was the
No,
return.
no.
Lordship,
5th April.
grateful to you.
Returnable 5th April.
Grateful to you, Lordship. Grateful.
Item number 34.
Take it now.
That is your lordship. My lord, already we have made Chief Secretary as respondent number 6 in this case. As per the earlier order, we have rectified, my lord. Before the rest, my lord.
Yes, will issue notice.
My lord.
Yes, Miss Sharma.
And my lord, our 4 representations are pending, my lord. At least give direction.
Let them respond.
Yes, my lord.
Mr. P.K. Dakal and counsel for the petitioners. Where is the state of Assam? Amended cost title.
Yes, my lord. Respondent number 6, my lord. State of Assam represented by Chief Secretary. After
MSS Sharma, Junior Government Advocate Assam for the respondent number 1, 2, 3, and 6.
Yes.
Full stop. Agree by non-consideration of the petitioner's representation. A amended cost title or second G2 in the matter of
my lord.
In the matter of in the annexure 6 a amended cost title. The petitioner has approached this court by the instant writ petition, issue notice returnable on so and so. 8-4. The petitioner has appeared, accepted, no formal notice. The petitioner shall take steps for service of notice by registered post upon 4 and 5.
Yes, my lord.
By registered post with AD within 2 of.
My lord, during pendency, my lord.
Okay, it is observed that pendency of the writ petition shall not be a bar for the respondent authorities to consider the representation of the petition on its own merits.
35. My lord, in this case, my lord, learned counsel for the GMC lordship was directed to, my lord, obtain instruction as to whether under what law it was, my lord, demolished lordship. Under
There
what
are
is the
complaints, my
procedure,
lord.
lordship?
First of all, there are complaints. Second is that, my lord, husband of the petitioner has earlier filed the same, that has been conceded. In 2008, he has filed that trade license was cancelled. He has filed a petition that has been concealed, my lord. Neighbors have complained, he's burning plastic. So all the along with photograph they are complete. And this has become a den for drug addict as well as drinking and all this.
If they have a very high-handed action, then we'll examine.
At the
And
same time,
plus,
my lord,
you seek damage also.
yes, at the earlier petition also, yes, husband has filed, that has been concealed.
I don't know, Lordship, nothing.
Yes,
I don't know what was there, what is was filed, Lordship.
Things are bit disputed, Mr. Ahmed.
My lord, the things are disputed, Lordship. This is the, my lord,
Let
demolition.
them respond
My lord,
by filing affidavit.
my lord, yes, Lordship.
In
Maybe
2008,
affidavit may be
the
filed, my
husband
lord.
filed and the trade license was cancelled, the petition was filed.
My lord, the affidavit comes, I will reply, Lordship.
Husband name is Ilya.
Even then, my lord, even it is, my lord, correct, my lord. My lord, in this way, my lord, it cannot be done. Demolition cannot be done without any.
Let me have a look at least before appreciating your submission.
Lordship. Affidavit may come, Lordship, I will reply, Lord.
So this is going on.
This was because then in the paragraph, second paragraph, which says last 26 years doing the business and no trade license was annexed. Only on when the online trade license, when the online was open, this was trade license was taken. It was not mentioned for any where the area will be. In the residential area itself, that business was going.
Same place.
Same place, my lord. Husband has earlier filed it.
Husband expired both. I don't know.
Because
Mr. Ahmed, it is not a short order. It is running
My lord,
into many
affidavit may come,
pages.
Lordship, I will respond, Lordship.
It is
What
a
is
long
there, Lordship?
order.
I don't know, Lordship, what is there, Lordship.
Because earlier it was stopped.
My lord, that is why I am submitting, Lordship, affidavit may come.
Court has already declared that the business carried out by the petitioner not at all conducive to be carried out in a residential area.
I don't know, Lordship, what is that.
So,
My lord, affidavit may come,
we'll
I will respond.
notice at this stage. Let them bring everything.
Yes, Lordship.
My lord, I am looking for respondent number 4, 5 and 6. Private respondent.
You are having a fighting with him, lady.
My lord, he has remedy under Rent Control Act, Lordship.
Huh?
My lord, they have remedy under Rent
Yes, it
Control
is
Act.
a landlord and tenant ultimately, and plus public complaint also. Heard Mr. M.H. Ahmed, learned counsel for the petitioner, and Mr. S. Bora, learned standing counsel GMC for the respondent number 23. M.S. Sharma? S. Sharma, learned new government advocate Assam for the respondent number 1. And Mr. S. Bora, learned standing counsel GMC for the respondent number 20. Close stop. You have filed any Ukalat Nama? Okay. Also heard Mr. A. Paul, learned counsel, who has entered appearance on behalf of the respondent number 4, 5, and 6 by filing Ukalatnama. Full stop. The petitioner has alleged unauthorized action on the part of the GMC authorities in demolishing the petitioner's
Business premises as well as part of
business premises
part
where
of residential.
the petitioner wherefrom the petitioner has been carrying out business in scraps after obtaining a trade license from the GMC. Full stop. It is stated that such demolition was carried out on 24, which date?
24
to 2022 without
24
20, 20.
24 to 24.
24 to without any prior notice.
Lordship. My lord, 2 days. Thereafter, on the file of the date of
And
filing
also
on the date of filing writ petition, Lordship.
Also on
27 to 2024.
27 to 2024. Full stop. On the other hand, Mr. Bora, learned standing counsel GMC, has submitted that the earlier the husband of the petitioner instituted a writ petition, WPC number 1961/2008. And the said writ petition was disposed of or dismissed?
Disposed of. It was
Disposed of by judgment and order dated 13/8/2008. Full stop. He has submitted that it was observed therein that the business which the petitioner's husband was carrying out was not conducive to be carried out in a residential area. Full stop. The trade license of the petitioner's husband was cancelled earlier by the GMC authorities. Full stop. Mr. Paul, yes, what is your case?
I'm the landlord.
You are with petitioner or with GMC?
I am against the petitioner.
Against the petitioner. Mr. Paul has also endorsed the submissions of Mr. Bora, standing counsel GMC. The matter would require further examination, issue notice returnable on so and so. 8/4. As all the so and so appeared, no formal notice. Extra copies within 2 days. The respondents shall invariably file their counter affidavits on or before the returnable date.
Under extra copies be served upon me.
Yes.
My lord, interim may be continued clause.
No
My
interim.
lord, otherwise,
No
my lord, I'll
interim.
be evicted lordship.
No interim.
My lord, evicted demolition.
Okay, let us
My lord,
consider.
Demolition is
Let
done,
us
my lord,
consider.
eviction lordship. Eviction part lordship.
We
Just
have kept
coming
it
again,
like
again,
that.
again.
Let us hear them. I'll
My lord, time is-
delay the rising.
My lord,
Yes.
my lord, only eviction part, my lord, GMC may not
Having
be done.
considered
My lord, yes.
the fact that
GMC has no authority. to evict.
this court in the earlier proceeding had observed that the place where the scrap business is being carried out is not conducive to be carried out in a residential area. The prayer for interim relief.
My lord,
declined.
as regards the eviction lordship,
Yes,
I'm
declined.
eviction, my residential. house
Is
is there.
declined.
Residential may be, my lord. I am, with respect to the residence lordship.
Next.
My lord, dwelling, my lord, cannot be. Lordship. That otherwise I would not have press hard lordship.
No, since you have,
Dwelling
I have
part.
decided.
My lord, dwelling part.
No, I have decided.
Then my lord, it may be, my lord.
No, I will not recall now.
It may be recalled lordship.
No, no, I will not recall.
Otherwise I'll be prejudiced.
I will not recall. I
I'll be
did not
prejudiced.
did not made any observation what was passed on the previous day. So I thought that it would be better to keep it. Now I have observed specifically.
My lord, that may be
Interim
recalled
relief
lordship.
is
My lord,
declined.
otherwise I'll be prejudiced, my lord. Eviction will be done lordship. GMC cannot be, my lord, do lordship.
There are others waiting.
My lord, the dwelling part.
There are others waiting.
Lordship.
Yes, next. Yes.
May I please? Petitioner are resident of Dhemaji, my lord. They are aggrieved by the inaction of the respondent authority in not properly demarcate the land, my lord. The land has been acquired, sought to be acquired by the highway authority.
Are you in the list?
Yes, my lord, not in the list. That is the grievance, my lord.
You are
My lord,
holders.
yes, my lord. Tracement shows that our land is the adjacent to the, connected to the highway, my lord.
Come to page 21.
My lord. Yes, this is the list, my lord. We are not in the list.
Now, okay, you are not in the list.
Yes, ma'am.
Just the sentence before the schedule.
That's it.
Above the schedule. The land plans and other details of the land to be acquired under the notification are available and can be inspected by the interested person at the appropriate office of the competent
My
authority.
lord.
Did you make a visit? Did you ask for any land plan?
That is the, but
See,
yes,
making a petition, writ petition is very easy. But whether you have done the homework,
No, my lord, since the list has been published, we have.
you're not there.
Yes, my lord. We
So
are-
detailed land plans are there already.
My lord,
And you have been asked to inspect
My
and
lord.
find out.
my lord.
Since your lands are not there in a list, you should have inspected the land plan and other details of the land to be acquired. Is it not?
From the sentence, says, my lord.
This is clear.
Yes.
Take your call. We'll fix it on another date.
My lord.
Find out. Mr. Talukdar, are you in a position to provide the land plan to him?
I have to obtain it, sir. I have to, but as per.
How long? It is a big. It
Lordship.
can be given online.
Lordship. I'll obtain instruction, my lord.
He'll
My lord.
obtain instruction. If it is, he can obtain it by online. It will provide it to you.
Yes, my
Then you go through the entire map.
lord.
Then thereafter, if you find that you have a case, you continue the repetition.
Lordship, as per notification, Lordship, they have to visit the office of the competent authority, my lord.
So I am told that
So,
their
Lordship,
names are left out.
The
That's why. And trace maps
That
shows
is
that.
why.
the competent authority, my lord.
And trace
Okay,
maps.
in the meantime, make a visit next
Well,
Friday.
Competent, yes.
Next Friday. Yes. You make a visit.
My lord.
Competent authority.
Heard Mr. P. Hazarika, learned counsel for the petitioners. Oh, for Monday.
Monday.
And Mr. R.K. Talukdar,
Lordship,
learned standing counsel.
Lordship.
NHIDCL.
Lordship.
My lord.
MS Bodole, what?
I'm for two.
Revenue,
I'm for two.
1.
Two.
C. Borua, NHI, 3. R.K. Talukdar, standing counsel, NHIDCL.
1 and 4, my lord.
1 and 4. MS S. Sharma, Junior Government Advocate Assam for the respondent number 5 to 7. Now, who is Kala?
Kala will be 5.
So, they will approach. If it is the case of the petitioners that their pattalens are adjacent to the proposed national highway project.
My lord.
Which page? Which page?
Page 21 will be notified.
Proposed national highway project. That is a page 21 building widening so and so.
National Highway
515 in the states of land from Iman to Iman. Okay. Okay. It is the grievance of the petitioner that in the notification bearing number is 21 SO 1342E dated 21/3/2023 issued under subsection 1 of section 3A of the National Highways Act, the petitioner's pattalens are not included. Post of the petitioners are the petitioners are in the apprehension that their pattalens are going to be affected by the project. Post of as the petitioner plot of pattalens are not in the schedule published in the notification dated 21/3/2023, and the petitioners have stated that they have not seen the land plans, the petitioners shall visit the office of the respondent number, competent authority, land acquisition, Kala, that is the respondent number
6, my lord.
6. In the meantime, to
demarcate the land.
To go through the land plans and other details of the land to be acquired under the said notification at the office of the respondent number 6. In the meantime, post of MS Sharma shall convey to the respondent number 6 that if the petitioners pay a visit to the office of the respondent number 6, the petitioners shall be provided with the opportunity to inspect the land plans and other details of the land to be acquired under the notification dated 21/3/2023. Lays the case on 11/3.
11.
Item 37.
Lovely. Well, it is similar to item
These
21.
are, let it be Monday or Wednesday. Nothing will happen.
Monday or Wednesday, my lord.
Otherwise, it is similar to 21.
Wednesday. Nothing will happen. Force majeure.
Lots of.
Force majeure.
Similar to 21, my lord.
RS Mishra. Petitioner. Mr. Gogoi, you are there.
Yes.
You have issued force majeure.
My lord.
Who has invoked?
No, Lordship, notice was issued by the central government because it is 50% is to be shared with the state.
168A. So Mr. Gogoi comes in, 50% Gogoi.
Yes.
Okay. SC Kyle, any CGC? Huh?
On behalf of the state, Lordship.
A Pukon CGC লিখে দিব. 1.
I'm 2 and 3, Lordship.
SC Kyle, sending us a CGST. 2 and 3.
Lordship.
Mr. B Gogoi, SGST.
Yes, my lord. Yes, yes.
SGST for the respondent number 4 and 5. As sought for by the land council for the parties, leaves the case on Wednesday. Same is 38.
Lordship.
Yes, any.
Sword is hanging on me. The last date was 29.
Some other sword is also hanging on me. That is a difficulty.
But I am still in the.
I have to sit in it. It is not that I am rising. I have a tribunal. I have a tribunal sitting now. That is a difficulty.
But,
It is not that meeting or something like that. Of Tripura, that is a difficulty.
Till Monday or so, some protection.
Monday.
Till then, I may not be evicted.
Mr. Who is state counsel in Mr. Soikia's case? State.
Circle officer notice.
MS Sharma, please ensure that nothing happens till Monday. I am not giving my MS Sharma. In item number, yes, WBC, please furnish a copy to her. Extra copy.
1253.
1253. MS Sharma, please ensure that nothing happens till Monday.
Call them up.
Right?
I will.
Which are circle officer or district
Circle
commissioner? Circle officer, which place?
Gwalpara, my lord.
This is
Gwalpara.
Mattia
Mattia.
Revenue Circle.
MS Sharma, please ensure nothing happens that till Monday. List the case on Monday. Huh? Today, 1253.
In item number, the second item, all I'm bringing is for disposal. That let the registrar of firms and societies give me my documents. Without it, I'm helpless.
Mr.
Only that much.
Who is your, who is threatening you?
It's not a question of threatening.
Then it can wait then.
My entire
If
body
that-
is gone. Entire body, some allegedly strangers have come. I'm the fancy bunch of Gurdwara, my lord. That committee is before your lordship.
No, who is threatening you? Any state authority?
No, I'm not. I am saying.
Any state body?
The
Please
state body.
tell me.
State body. The
Who?
registrar
Which
of
is
firms
the
and
state
societies should just give me the documents. That's all.
Which is the state body, Mr.?
State body is registrar of firms and societies, Assam.
What he is not doing?
He's not giving me the documents. My elected body members' documents are there. Some
Please wait till Monday.
The Sangha is difficult to run. Only a direction, dispose of, let him give me a document.
Mr. Bonik, it is.
I'll give it in Monday.
I granted you permission with the condition that subject to.
Monday at 2.
Subject to.
At 2 minutes.
Monday, list on Monday.
Monday.
List on Monday. It will
Lordship,
come.
I beg your indulgence, your lordship. Item number 30, your lordship. Lordship, I am
You please permit Mr. Das, a senior counsel, to make the submission. At least please maintain that decorum also at the same time. Everybody has an urgency.
I'm sorry, my lord, I am not.
Yes.
Hello, item 22, my lord, the Canara Bank matter. What I'm praying is when I may be allowed to withdraw with liberty to file appeal before the tribunal. And in the meantime, my lord, that interim order which is there, let it be there for 2 weeks.
I think he agrees, sir.
Yes, your lordship.
Reasonable enough?
Yes, yes.
Okay, I'll pass the order.
2 weeks, the
You-
interim order will continue.
That is section 30,
Yes, section
Section
30 of the
Every-
RDB Act.
they file affidavit.
public debt PSL, what is the act?
Recovery of debts and Bankruptcy Act 1993.
দিব ফাইল টোৰ লগত দি দিব 15 days
15 days.
status quo till
15 days.
Yes, yes.
15 days
I'm deeply obliged. Good.
and it will be subject to further orders of the to be passed in appeal
If filed.
If filed.
if
Yes.
if file
Yes, your lordship.
Otherwise, it will go, my lord. Obliged.
yes
Basically,
Mr.
they have challenged the sale certificate. So
Item 26, there is some urgency, may be taken up in the next
Wednesday?
Wednesday, Monday.
Wednesday. On the request of Mr. H.K. Das, learned counsel for the petitioner, list the case 26 on Wednesday.
I know.
Made to your lordship. Lordship, I beg to mention item 31, the 200 city buses irritating matter, my lord. I have filed my affidavit.
Good enough.
Lordship, may
When
I-
do you want?
as per my lord convenience, next week, my lord.
Next week, Monday?
Lordship.
Monday, Mr. Okay. Likhok, anybody?
Yes,
on the
petitioner
petition?
counsel.
I'm for petitioner.
Mr.
Yes, Sharma.
A. Sharma, learned counsel for the petition is present. First of MS MD Bora, learned standing counsel, Transport Department has submitted that a counter affidavit on behalf of the respondent Transport Department authorities has already been filed
My lord.
and matter be listed after a week with the said counter affidavit on record. To stop as a sought for by the learned counsel for the parties, list the case on 11th.
I'm so deeply obliged.
The interim order passed earlier shall continue
Lord.
till the next date of list.
In the meantime, they may file their reply, my lord. Or else again, they will take time on 11th.
Okay, the petitioner shall file. Petitioner may file their affidavit in reply. In the meantime, if so advised.
My lord, deeply obliged, lordship.
Yes, Mr. Diwan.
Lordship, before making submission, I beg you indulge the seal because I have not seen the senior, your lordship. So my submission, your lordship, item number 30, your lordship. I am under preventive detention, your lordship, since 7 months, your lordship. The other side, they have filed the affidavit of opposition. I want to file a reply, your lordship.
How much time?
Two, maximum 1 week time, your lordship.
1 week. Mr. Item
Item 30.
A. Diwan, learned counsel for the petitioner has paid for and is granted 1 week time to file affidavit in reply to the affidavit of opposition filed by the state respondents.
Lordship.
MS Sharma, learned junior government advocate Assam for the state respondents is present. Please the case 13 month hobo sage 15. 15.
Much obliged.
Item 28 of today's list, my lord, there's an interim protection.
Okay.
Due to paucity of time today, it's not possible.
Okay.
Any date.
List. Okay, on the request of Mr. A.K. Bora, learned counsel for the petitioner, and Mr. R. Bora, learned counsel for the respondent. List the case on 15-3. The interim order passed itself. Continue till the next.
Item number 25 is interim order, madam. 25 interim order is dated till today.
Okay, on the request of Mr. R.S. Mishra, learned counsel for the petition, list the case on so and so date. The interim order passed itself continue till the next date of list.